That's June 6th. Hey, I mean, wait. Right. Back to 15, no, on the next thing. Yeah. Still there was a drag. Oh, I hate we talk about was like we got. Yeah, it was all, then, air spot. Air spot. Okay. One. Oh. Well, it's just. All rise. All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have two cases on this morning's regular calendar, and we have switched the order, as I assume most of you in the courtroom are aware, in order to accommodate a couple of attorneys who are going to be appearing remotely. And let's hope this goes okay. I will call that case. It is 23 CV 240. Simon Bronner et al. Versus American Studies Association et al. Mr. Waxman, you I guess are the one lawyer arguing for the appellants, and we have three arguing for appellees, right? So we'll address that when we get to you. Thank you.
Correct. I'm arguing for the appellants, and I'm actually here, not sick so far as I know.
All right.
If the court pleases, if I could reserve 3 minutes of my time for rebuttal.
Absolutely.
May it please the court. For over 8 years, 4 professors, longtime members of the American Studies Association, have sought relief for a series of corporate torts that have wreaked financial havoc on the association and its encyclopedia. This court should reverse the trial court's erroneous dismissal of their claims as time barred and as slaps, so that the claims can finally be adjudicated on the merits. As to the time bar, the plaintiffs promptly filed this action when, after 3 years of litigation, the federal court reversed 2 contrary prior jurisdictional rulings and concluded that the requisite amount in controversy couldn't be satisfied. Because the defendants have never suggested prejudice and the plaintiffs timely filed their initial action and have diligently pursued their claims, the trial court should have equitably told the statute of limitations. It erred in holding as a matter of law that equitable tolling is categorically unavailable if the plaintiff mistakenly sued in the wrong court. This court's decisions in Simpson, Mathis, and Brewer show clearly that that understanding of the law is incorrect.
But bond is your problem, right?
I think bond is not a problem. Bond held, I think bond is distinguishable in 2 respects on its facts, material respects. But in any event, bond itself never held that categorically as a matter of law, under no circumstances would equitable tolling be available if the reason for missing the statute of limitations was that you timely filed in the wrong court. And I think it's impossible insofar as bond, I think it's fair to characterize the court's opinion as reluctantly applying the statute of limitations and not applying equitable tolling, did not involve a situation like this in which.
But not every mistaken filing in the wrong court is eligible for equitable tolling, right?
Well, I think, Judge Ruiz, I think it's probably more accurate to state in light of your case law that in theory, one could raise equitable tolling anytime one missed the statute of limitations, but it is true that it will be the exception rather than the rule that the equitable tolling standards would be satisfied. And as this court has explained in Mathis and other cases, what equitable tolling requires is, quote, balancing fairness to both parties, considering 2 factors. One, was the plaintiff's delay undue or unexplained? And on the other hand, is there, quote, injustice or prejudice to the other party? And in this case, neither of those is satisfied, as it was not in Simpson, Mathis, and Brewer.
You rely on the U.S. District Courts, twice kind of saying, yes, we have jurisdiction. But in light of what the D.C. Circuit said in affirming subsequently, why is this kind of the special case to apply equitable tolling. And I get your point about the no prejudice, which is an important prong of this, but on the, basically, should the plaintiffs and their counsel have not known not to file in federal court?
Well, that, of course, would be a consideration in balancing the fairness in terms of whether there was undue delay. I mean, in Bond, for example, what the court thought important that the plaintiff waited until I think it was 3 days before the statute of limitations ran to file in the first place, that there was nothing that the initial court did or that the government did that in any way suggested that that was the right court, and that there was no possible allegation that the plaintiff in that case was relying on the fact that the other thing would be that the case didn't involve any unanticipated change in circumstances. So I would say that if this were the case, Judge Ruiz, that, for example, we knew for a fact that we were claiming subject matter jurisdiction under some statute, for example, 1331, federal question, when it was perfectly obvious that none of our causes of action involve federal questions. Maybe there's some First Amendment defense there.
The way you're couching it makes it sound a little bit as though there's sort of no thumb on the scale. It's just the claim is equitable tolling. I sued in the wrong court. Later was determined there was no jurisdiction in that court, so now promptly come to this court. Your opponent suggests that's not a correct description, even assuming that you're correct and there's not a flat bar to equitable tolling if you've sued in the wrong court first. They rely, among other things, on a case of ours called Curtis, which is post-Simpson, which is very similar to your case in its basic structure, in that somebody filed in federal district court first, and then there was a determination of lack of jurisdiction there, I think, on diversity grounds. And then our opinion is not kind of well, now we just have to weigh the equities one side or another, and there were some pretty compelling circumstances, and here's what the prejudice was. It's really very inhospitable to the idea that that would be a basis for tolling. I don't know that there's a flat rule, but it's pretty inhospitable. So what do you make of Curtis? If you're right, Curtis is missing a lot of the analysis it should have had, which would have been, let's look in now to, so this is a kind of circumstance that can create equitable tolling. Here are the pros and cons. Here's the balancing. Here's why a determination was warranted or not warranted, but none of that is in Curtis.
So I'm struggling to bring Curtis to mind, but perhaps I'll have further thoughts in my rebuttal. But the fact of the matter is this court has said over and over again, I'm not suggesting that following Simpson and taking into account Matheson, Brewer, and Neal, that the court always equitably tolls or always discusses equitable tolling in a statute of limitations case.
Well, just to give you the quote from Curtis, this is pretty much the entirety of our discussion of whether equitable tolling was warranted because of the suit in the wrong place. We said, we have held, however, that there is no basis for finding that filing a suit in another jurisdiction tolls the statute of limitations here, than citing an old case of ours and Bond. And then we discuss Bond a little bit, and we say the efforts to distinguish Bond, there's no significant distinction between this case and Bond. And what do you think so that's the question is, so what do you think is different about this case from Bond?
Well, so what I would say, first of all, is I don't think that the sentence you read me is actually a holding of the court. And I think insofar as it can be read to suggest that equitable tolling is in fact unavailable, if the reason for the statute of limitations issue is that you filed in the wrong court. And I've cited again and again 3 post-Bond cases that have held to the contrary. I think the distinctions between this case and Bond, Judge McLeese, are twofold.
To be clear, one of those is equitable tolling with respect to statute of limitations. The others are equitable tolling in other settings, right?
I'm sorry.
The other 2 are equitable tolling in settings other than statute of limitations. Is that correct?
No, I don't think so. I think they all involve, whether you call it statute of limitations or non-compliance with a requirement that judicial review be sought within a certain number of days, it's effectively a statute of limitations in the context of an attempted review of an agency decision. Those are statute of limitations principles. And the distinction.
I guess I wouldn't have thought that those timely filing requirements are, I mean, they're analogous for sure, but I don't think of them as doctrinally or analytically considered.
I
statute of
don't
limitations,
think, this is an interesting discussion. I don't think anything actually, in my mind, nothing turns on this distinction. But as this court has held, statute of limitations are not, they are procedural, not substantive, and they are claims processing rules. I'm quoting Mathis, not substantive jurisdictional rules. And the same.
Well, Mathis was a timely filing requirement, correct? So when you say statute of limitations in the sentence you just described, I don't know that Mathis said it.
Oh, maybe I'm remembering the wrong decision, but this court, I think, has said that statute of limitations, provisions that require that you bring suit in a certain time are procedural rather than substantive. And while not all procedural rules are non-jurisdictional, claims processing rules, by which the court said a requirement that you go to court within a certain time, are not jurisdictional and therefore in appropriate circumstances are subject to equitable tolling. Your Honor asked, I want to make sure that I answer what might have been your original question, which is how do we distinguish this case from Bond on the facts? And I think, as we suggest in our briefs, I think the answer is twofold. Here, as in Simpson, for example, and Mathis and Brewer, there was an unanticipated change in legal rulings regarding jurisdiction.
Unanticipated by your client, but advocated for by your opponent early on. So your client would have known from the get-go that it was a disputed question whether jurisdiction was proper in the district court. And the circuit ended up saying your opponents were right.
So, for example, in Mathis, when there was an adverse determination from the agency about, I don't know, the end of a rent supplement payment or something like that, the plaintiff filed in Superior Court. There was a suggestion, the Superior Court said, I'm not sure you have jurisdiction here, but the government, the DC government, said that the Superior Court did have jurisdiction. So the Superior Court went on to decide the claim. On appeal, this court said, there wasn't jurisdiction because this was a final adjudicatory order of an agency and it comes directly to the DC Court of Appeals. And therefore, your invocation of our jurisdiction is not timely, but we will waive that objection. Here, as in, for example, Simpson, there was a reliance on the fact that you were in the right court, both because you filed there in good faith and because there was both an unanticipated change in the law, which is we filed, there was an immediate motion to dismiss for lack of subject matter jurisdiction. And the district court held not once, but then twice that in fact it had subject matter jurisdiction. The second time, even though it had already held that there could not be any derivative claims. And then the third time, the court just said, well, we've been dancing around this issue, but now I find that there isn't the requisite amount in controversy. And
I thought the circuit observed that at that second time, correct me if I'm wrong. Yes, the district court said, I think I have jurisdiction, but it was kind of caveated so that there was a red flag next to the jurisdiction.
Yeah, what Judge Contreras said the second time is the issue of subject matter jurisdiction is before me. I have to consider the issue of subject matter jurisdiction because I always do, even though the motion to dismiss has not been renewed. I have ruled that all derivative claims are out of the case. I nonetheless find that there is subject matter jurisdiction. If further developments lead the defendants to move to dismiss for lack of subject matter jurisdiction, I'll consider it They never did move. The court in its third, the district court in its third ruling, it was its fourth ruling, but the third jurisdictional ruling held, simply stated without any reasoning, that it was now time to come to grips with the jurisdictional issue.
And where does the amended complaint come in that sequence?
The
Because
amended,
that made a difference to the circuit, right?
the amended complaint came, I can't remember whether it was before the second ruling or the third ruling. But, the Judge Rigsby, when the case was filed here, found that with respect to the initial filing of the complaint and the filing of the second amended complaint, there was no statute of limitations issue per se in the district court because of the application of the discovery rule. And I want to say that at no time in the 3 years that this case was actively litigated in the federal district court did the defendants ever move to dismiss under statute of limitations grounds. So when the case came to the Superior Court under the complaint that had been the second amended complaint filed in the district court, until it was filed in this court, there had never been a statute of limitations ground. The statute of limitations issue here, the plaint that the defendants raised, was that it is now too late. You're now filing in Superior Court and more than 3 years has passed.
Well, then that was indisputable, right, with respect, and that was true. It's, absent equitable tolling, that was accurate, right?
No, I
No.
think,
Well,
no, Judge Rigsby in his initial ruling did not dismissed counts 3 through 8 of the 12 counts on statute of limitations grounds and dismissed portions of counts 2 through 9. But not as to all of the
Not as
counts.
to all, no, I agree.
So unless the court has further questions, I see my time has expired, but on the anti-SLAPP rules, if I could just point out what I think are the two errors of the trial court. As to step 1 of the anti-SLAPP statute, the motion fails because none of the claims here are predicated on the resolution itself and certainly not on any, quote, legally objectionable aspect of its content. The trial court ignored this court's earlier holding that it is, quote, not enough to find that the resolution related in some way to plaintiff's non-speech causes of action. And this court suggested in its prior opinion that counts 1 through 4, 6 and 7, and 10 through 12 are not based on protected activity. And with respect, I would like to suggest that neither are counts 5 and 9, which allege that the defendants violated the ASA's bylaws required to maintain its tax-exempt status and wasted corporate assets in supporting a resolution that had never been lawfully enacted.
Can I ask you about count 1, just to walk
Yes.
through an example? So, I assume you take as a given, but let's find out, I guess, if the head of an organization makes a statement about a matter of public concern to the public, so it's a public statement, matter of public concern on behalf of the organization, and somebody files an action, again, a member of the organization or a shareholder, if it's an organization that has shares, files an action alleging that that statement was a breach of fiduciary duty that the head of the organization had to the members or shareholders. Do you agree that if I tell you those things, you would say, yes, it's covered under the Anti-SLAPP Act, or you think it is not, or you need more facts?
I think I would need more facts. Under the facts that you've given me, what I can say is that that doesn't remotely resemble any of the counts here.
Understood. I'm just trying to get to
Yeah.
step 1 of, I'm trying to see exactly where you are pitching your tent. So
Yeah, so where
why would those facts by themselves not establish that the act is covered? Partly I'm trying to figure out how much your argument turns on the elements of the claim you're asserting and how much it focuses on the nature of the activity that is the actus reus of the.
All right, so let me go right to that. I count at least 3 times in your prior opinion in this case. I believe it's 3. I have 2 firmly in mind, where the court said, look, what the inquiry has to be on the elements of the cause of action asserted and whether protected speech under the SLAPP statute is an element. For example, the court said, in its holding, said that this is on page 354 of the joint appendix. We hold that the prima facie showing required to support a special motion to dismiss claim under the DC anti-SLAPP statute is showing that the claim is based on movements protected activity, i.e., that such activity is an element of the challenged cause of action. And likewise, the court said at page 352 of its opinion, this means that in ruling on an anti-SLAPP motion, the court should consider the elements of the challenged claim and what actions by defendants supply those elements and consequently form the basis for liability.
And that
So,
it's the second half of that I'm focused on a little bit, because I mean, it's never an element of breach of fiduciary duty in the abstract that there be any kind of expressive conduct. So if
correct.
you're looking at just like, do I look at this offense in the abstract? Does it have an element that is speech related? Then the answer is no.
So
So is your position that like categorically, unless in the abstract, speech is a expressive conduct of a kind that would be covered by the
well, here's,
anti-SLAPP Act is
let me
categorically out?
yeah, I'm sorry to interrupt you. Let me explain, let me give an answer to that question and then explain how I think count 1 is properly understood and why it doesn't fit that paradigm. If the claim of breach of fiduciary, if let's say we have, somebody is a fiduciary of the American Red Cross and makes a public speech extolling genocide, one can imagine a breach of fiduciary duty claim, which would be covered under step 1 of SLAPP, because the cause of action itself, the reason for the breach was the content of the speech. You cannot be a fiduciary of the Red Cross and extol genocide, period. What we have in count 1 is a claim that the defendants or those defendants implicated in count 1 knowingly and secretly conspired to misrepresent to the membership their plans for the organization should they be chosen for the nominating committee.
Well, let me
That
ask
is-
you about an aspect of that. So I think that that count has a variety of actions that are part of the alleged actus reus of the course of conduct that was alleged as the breach of fiduciary duty. But a component of it seems to be omissions from statements that were made by folks who were running for positions internal to the organization about what their actual plans for the organization were. Am I right that that's part of the actus reus that is alleged in the complaint?
Yes, I mean, the actus reus alleged in the complaint is that both that they materially misrepresented their plans and that they deliberately omitted a correct characterization of what their plans were.
And would you agree that if one is making statements and the question is what is in or not in, that what you include in a statement you make and what you exclude is expressive conduct?
Well, it's not public. I mean,
I'm just asking you about expressive conduct first.
oh, if I make a statement that my plans are to, push for tenure for American Studies scholars, that's certainly an expression. I've written that out and sent it to the membership.
And so the reason I'm asking about expressive conduct as step 1 is because the definition of act in furtherance of a right of advocacy for purposes of 165501, one part of that definition, part 1B, is any other expression or expressive conduct. That's why I was asking about expressive conduct And then it says that involves petitioning the government or communicating views to members of the public. I'm assuming, I haven't heard your opponents argue otherwise, the statements that were made internal to members of the organization about the plans for the organization are not themselves public statements.
Correct.
But the question, I guess, is whether that is expressive conduct that involves communicating views, because it's about, again, it's an omission. I'm saying what my plans are. It's an omission about what public statements I plan to make. You don't think that involves?
That's correct. I think when it says that it arises, that whether the claim at issue arises from an act in furtherance of the right of advocacy on public issues, which is the prong that we're talking about.
Well, right. But the definition, I mean, again, act in furtherance of advocacy includes non-public expressive conduct.
Well,
You
let's
agree or disagree with that?
let's be very, very clear about the scope of the DC statute. The original SLAPP law as proposed included acts in furtherance of, as the California statute does. And I mean,
There's got to be
yes, it's
expressive conduct. But my point is, would you agree or disagree that this statute defines acts in furtherance of to include expressive but non-public conduct if additional requirements are met? So the act in furtherance of doesn't itself have to be a public statement.
Yes, if our claim in this case.
Well, my
was-
question is just about the meaning of the
Okay.
statute. So I'm just trying to figure out whether
As you're phrasing it, I don't think that if there is an act, if there is a public act that is an expression on, to the public on a matter of expressive activity, I'm not suggesting that there can be no prior conduct, that if there's any conduct prior, if it's anything other than an excited utterance, that evidence wouldn't be, that evidence would prevent step one from being satisfied. What I am suggesting is taking, I think paying careful attention to footnote 78 of this court's prior opinion, that, for example, a claim that you misappropriated association funds or corporate funds doesn't get you into step one if you claim that, well, the reason the misappropriation was to use it to make a public statement.
So to be clear, just that I've wondered a lot about that footnote and the lines that one might, infer from it. But so imagine that I am the head of an organization and I'm going to make a public statement on a matter of public concern. And what I do is that let's say it's, for example, about the importance of, diversity, equity, and initiatives in the workplace. And I think it's important for my organization to say that, and I'm not betraying in my mind, I'm trying to do a good thing, let's say, or at least that's what I claim. And I, rather than myself making that statement, I take corporate funds and I hire a PR firm to put out a statement on my behalf or on the organization's behalf. Would you say that if someone is sued for breach of fiduciary duty, saying, that destroyed the organization, it embroiled the organization in a terrible controversy and was, abandoning the interest of the organization, and their claims is they have two actus rea or whatever the plural of actus, acta rea. I never took Latin.
Acti.
Yeah, right. One of them is, the actual statement itself that I caused to happen. I think you might think that would be covered at the first step of the Anti-SLAPP Act. And the other is the taking of those corporate funds to hire somebody to disseminate that statement. Would you say covered or not covered?
Well, I would say that if the taking of the funds constituted a misappropriation, that is something you had no authority to do for that purpose, irregardless of what the statement would say, then it doesn't meet the plaintiff's burden under step one. And
I'm assuming, I think it's that seems like a very reasonable answer off the top of my head.
Well, I'm
But do you
relieved to have
implicitly,
gotten at least this-
are you conceding that if the nature of the breach of fiduciary duty is that was a misappropriation of funds because it was the taking of funds that are intended to be used for the corporation, and because of the content of the statement, it really doesn't advance the interests of the organization, covered or not covered?
I mean, I think I can imagine circumstances in which it is covered and not covered. If the example that I gave about the Red Cross, I took $100,000 to publicize my, valedictory speech that the world is overpopulated and what we need are more genocidists. It is utterly clear that that is contrary to everything the American Red Cross stands for. And it would be a misappropriation. Here, what we-
And you're doing that as president of the American Red Cross? I mean, because here, one of the things I've been struggling with in that footnote, which is about embezzlement, right?
Or misappropriation.
But the notion is taking of association or corporate funds for personal use, right? As opposed to here, where the funds were used on behalf of the association, right? They hired people to represent clean up whatever the mess was that had been created, the bad publicity, if that's what you want to call it. So the misappropriation is because of that what required the expenditure were all these prior we'll call them prior bad acts. What's the misappropriation part of this?
Well, so if we're still talking about count one, we have not, none of the counts here allege misappropriation simpliciter.
Misuse of funds.
No, so count one, if we're still on count one, has nothing to do with funds. Other counts
No,
do.
but there are others.
Yeah.
Yeah.
So, I mean, for example, count 9, which alleges corporate waste.
Yes, that's a good one, because isn't the corporate waste, well, tell me.
I'm trying to pick on the ones that you expressed skepticism about before.
Right,
Right. So count 9 basically says, look, it is corporate waste for a fiduciary of a corporation to spend substantial amounts of money to support an illegal act. We have alleged in counts, I believe it's 6, 7, or maybe it's 6, 7, and 8, that this resolution, that each of the defendants knew to a certainty that this resolution had never been enacted. They didn't meet the quorum requirement of the DC Corporation Act, Nonprofit Corporation Act, and they didn't meet the 2/3 majority dictated by the Constitution and bylaws of the American Studies Association. They knew that. They'd had any number of complaints which they suppressed and did not publicize. And they then went and spent hundreds of thousands of dollars, including raiding the trust fund, which had never had funds expended before, in order to, quote, defend and promote the resolution as if it constituted a statement of the association. That is a statement of waste that doesn't depend at all on the content of what the resolution said. The resolution could have said, and this is true for all of the counts of the complaint, the resolution, the supposed resolution, could have said, we want to boycott on any interaction with Iranian universities because we believe that Iran is set to the destruction of the world or the destruction of Israel or whatever it is. The point here is none of the causes of action in this case depend on the speech itself. And it's certainly, and I realize this is a question that I've struggled with. I think it's an actual open question in this court, whether an element of the claim has to be public speech on a matter of public importance or the content. I think this court's opinions are best read as suggesting that it's the content. After all, in the very second paragraph of this complaint, you describe SLAPP as a statute aimed at addressing efforts by one side of a dispute to silence efforts on the other side of the dispute.
I thought if you're talking about content, I would have thought that a number of the counts in the complaint turn on the content of the resolution. So if the content of this resolution had been we should redouble our efforts to reach good conclusions about American studies. I would think that a number of your counts wouldn't function, because some of them about being part of a conspiracy to make statements that are inconsistent with the purpose of the American Studies Association, and they're contrary to the views and known to be contrary to the views of most of the members and all that. All those would not be viable if the content of the statement had been different. Now, you're right about viewpoint. I mean, a lot of the points you make in the complaint would work the same if an opposite viewpoint had been expressed in the resolution. I get that.
Okay,
But if the issue is content, I see it a little differently.
All right, I probably should have said viewpoint. I wasn't focused in on the content viewpoint distinction. I mean, as this court said in beginning its opinion in the last time it had it, it said that SLAPP is, I'm quoting from the second paragraph, SLAPP is used to refer to, quote, an action filed by one side of a political or public policy debate aimed to punish or prevent opposing points of view. And that's citing to the court's prior decision in Mann. Likewise, the court says later in the opinion at page 351 of the joint appendix, a legally objectionable aspect of the protected speech itself. For example, that the speech is defamatory or otherwise tortious or violates a contract's prohibition must be the subject of a claim or an element of the cause of action asserted. And that to me seems to suggest that I think I would call it, it's probably more accurately called viewpoint, certainly with respect to the first quote I gave you, but that is an element of the case. And no count of this complaint would be different if the resolution were proposed and supposedly enacted, chastising Iran or asking for a boycott of Icelandic Vedic scholars or anything like that. There's nothing in this complaint that depends on the content of the resolution.
Well, can I ask?
I take
The viewpoint of the resolution.
Correct.
I get hung up when you say.
Yes, I'm sorry, the viewpoint of the resolution. Let's put it this way. If, consistent with the disclosed plans of these candidates for these nominees for the National Council had said, we just wanted, our plan is to support American studies professors in any way. And they then proposed a resolution, maybe it was even enacted, that scholars should be given tenure, or the American system of sort of liberal education depends on tenure for scholars. Nobody would be arguing that there was in any sense a waste of corporate funds or that there had been a knowing and active material misrepresentation of what the plan was.
Can I go back to, I count the 9, I think it is a corporate waste. I thought that part of the argument behind the corporate waste count was that as a result of the adoption of the resolution, meaning what it said, the viewpoint it expressed, there was a fall off in donations, membership, and actions that were taken by others, including governments, not to, I guess, maybe the association got grants or something, and that because it took this action, adopted this resolution, it was no longer eligible. So that membership, donations, and perhaps these kind of other opportunities were lost as a result of the adoption of the resolution. Why is that not really tied to the viewpoint expressed?
So I would say the cause of action for waste, which is the cause of action alleged in count 9, has to do with the egregiously unauthorized spending of corporate funds. It doesn't have to do with membership declining.
Well, I read that somewhere.
No,
Make it up.
it's very much in the complaint and is very much a part of the injury alleged by
Right.
these four professors.
But you're saying it's not the element,
The-
it's not
right.
part of the element of the claim.
Right, the element of waste is the expenditure of corporate funds without any legitimate justification, the expenditure of substantial corporate funds without any legitimate justification. And the complaint, the count alleges that the spending of these hundreds of thousands of dollars in support of a resolution that the defendants knew had not been adopted is corporate waste.
Well, I'm looking at the count 9 right now, and I actually don't see anything in it. I mean, it does say at one point that the individual defendants declared it enacted rather than it was enacted, but the way it describes the reason, the nature of the problem, it's the decision went so far beyond the bounds of reasonable business judgment, not it was like never enacted and you shouldn't waste money on illegal acts, but it's beyond reasonable business judgment, bad faith, conflict of interest, for purposes outside those established by the organic documents to advance their own political goals, all of which turn on the content of the statement. And then they're insistent on adopting the boycott, knowing that it would damage the association financially, I assume in virtue of its content, not in virtue of, oh, by the way, the damage here wasn't, this is a terrible organization. It miscounted the vote, and therefore it's not really good at determining which of its resolutions were actually passed. The damage, as alleged, is because of the content of the boycott resolution, or am I
So I
misoriented?
certainly the way I have understood it and the way the case has been briefed throughout, it's a combination, because the issue is, was it corporate waste to spend money promoting the expression reflected in the resolution? Defending the fact, the resolution, and using it as the lobbyists hired by the defendants did in advertising that this is the position of the American Studies Association, is waste because it is not a resolution of the American Studies Association. And
Can I ask you
of
about the
course-
relationship between pieces of this? Because if I'm oriented correctly, which I may not be, that aspect of the complaint, the idea that because of the manipulation of the vote, it is actually not a valid resolution. The trial court thought that was time barred. So for that to be part of what's alive for purposes of count 9, do you think that we would have to also rule in your favor with respect to the time bar aspect of it? Or do you think that that's independent of the statute of limitations question? I thought the trial court said that the manipulation of the vote counts were time barred. That was
the trial court said that the manipulation of vote count,
and that's a subset of the allegations, I get
that the vote itself, the trial court held, was outside the statute of limitations as the court understood that to apply. That doesn't mean that the subsequent devotion of substantial corporate assets to something that the corporation knew was not the position of, was not consistent with what was not the position of the American Studies Association, whether that had happened 5 years before or 500 years before, wouldn't impact the statute of limitations with respect to count 9. If I'm
I'm trying to recall the trial court held that part of count 9 was time barred, but not all of it. And I have to say the details of that are a little furry to me. But I get your theory.
I think
if I understand your theory, it is even if the trial court was correct that you're time barred in directly alleging that as an independent cause of action, to the extent there were non-time barred actions that involved expending money,
right.
You could challenge those on the ground that although you can't directly get relief with respect to the illegality in your view of the calling in a resolution when it really shouldn't have been, you can still challenge the expenditures that are not time barred.
That's right. And we had alleged a number of expenditures leading from, as defendant Stevens acknowledged in his deposition, leading from hiring public affairs specialists to advocate the position of this resolution even before the resolution was proposed to the membership. And as to those activities, Judge Rigsby said that's beyond the statute of limitations, but all of the activity following and the expenditures following what he called the time barred activities relating to the vote itself are not time barred because these are actions. These are allegedly wasteful acts that occurred within the statute of limitations. I'm not sure if I've tried your patience or you've tried my endurance, but I just want to make sure I have a chance to say like three sentences about step two, because it seems to me that, there are, as this argument has reflected, there are some deliciously interesting interpretive questions about, is it content? Is it viewpoint? How tangential does it need to be? Does it need to be an element of the cause of action? And what does that mean? But on step two, the Superior Court held in the first instance that our, whatever it is, 330 paragraph complaint proffered sufficient evidence to meet the very low burden that it was satisfied that you could not say that we, as a matter of law, we had no chance of prevailing on the merits of our claim. And instead, on remand, the court said with respect to the very same complaint that it didn't amount to evidence. And I would say that our complaint does, and we can go through each count if you want.
Well, just as an abstract question, the word proffer as used in our anti-SLAPP cases to me is pretty confusing as between sometimes proffer just means I'm standing up in court as a lawyer and telling you that if push came to shove, I could present some evidence to you. Sometimes it means presented in the form of evidence, and it's a little opaque to me. Is it your position that with respect to the step two inquiry about likelihood of success on the merits, as we've interpreted that in Mann, for example, that the allegations in an unverified complaint must be taken as true and proffered? Is that because if so, then it's not, we were way off in Mann to analogize it to summary judgment, because that's definitely not true about summary judgment.
Correct. I think this court has made pretty clear that you can't just file a speaking complaint and have that constitute a proffer. The way that this court's opinions have dealt with proffer is to say, produce evidence or a proffer that, admissible evidence will be provided. What we have here, of course, is not just some speaking complaint that, we say you did X, Y, and Z. We have cited to and quoted from in the complaint public records, dozens and dozens of statements made by the defendants in documents they provided to us in discovery, identified by Bates number, and something like 40 admissions in the answer, which under this court's jurisprudence is evidence. And insofar as proffer constitutes something other than, Your Honor, Seth Waxman for the government, I'll proffer that we're going to call the following witnesses who will say this, but not that here is their sworn testimony showing that, in fact, I have the evidence. It's someplace in between. This is surely the case, particularly when, as we point out in our briefing, the defendants in this case opposed even the filing of the second amended complaint sealed because, as Mr. Defendant Salida points out at page 12 of his footnote 6 of his brief in this court, I allegedly violate the terms of Judge Contreras' protective order just by reading the complaint. The notion that we wouldn't have had 6 months of motions practice I guess it would have been my co-counsel, had just filed an attorney declaration attaching all of the emails in the case. That would surely constitute more than, I mean, it would be the submission of what we assert is admissible evidence, goes beyond a proffer. And particularly in the, I mean, it just can't be that we lose on step 2 because we didn't actually put those emails in the form of exhibits to an attorney affidavit. Particularly when, and I think the circumstances here, the equitable circumstances here are pretty powerful. We use the complaint with all of its references to Bates documents, et cetera, as our satisfaction of step 2. In Bronner 1, Judge Rigsby said, that's plenty of evidence. In this court, in the appeal to this court, I think one of the defendants said, in addition to the grounds on which this court ruled, hey, that complaint isn't evidence. This court didn't address that issue at all. And so on remand, on direction of this court, we didn't have any reason to say, okay, now we have to put these things as exhibits to an attorney declaration. So at a minimum, if this court were to hold that that satisfies, but not the identification and quotation of, their statements and public materials and their answer, we certainly ought to be allowed to go ahead under the circumstances, go ahead and satisfy whatever this court thinks is the requisite form. Thank you.
Thank you very much, Mr. Waxman. We will give you a few minutes on rebuttal. And for the appellees, Ms. LaHood.
Actually, pardon me, Your Honor. Good morning. My name is Tom Magavro. I'll be speaking first. I represent the American Studies Association and a number of the individual appellees. First, I'd like to take 8 minutes of your time.
Can I interrupt just to ask you how you plan to divide your time?
Yes, Your Honor. I'll take
Apologies if you were about to say that. I thought you were jumping into your argument.
No. I will take 8 minutes or as long as the court holds me here. Ms. LaHood will take 4 and Mr. Kleinman will take 3. That's the way we've parsed it out.
Okay, thank you so much.
And one more thing, I want to thank the court for accommodating me, and I want to apologize for any disruption. It certainly wasn't my intent. Your Honors, I'm afraid that Mr. Waxman got a number of things wrong on both law and fact. Difficult to know where to start, but let me start briefly with the question of the statute of limitations. The factual mistake, fairly patent, as the court asked whether or not, where the amended complaint came in on the district court's ruling, federal district court's ruling. Fact of the matter is that the amended complaint was filed. The court sua sponte asked whether the plaintiffs could recover from the individual defendants. That was argued, and the court said, the question of subject matter jurisdiction, while before me, must wait for a well-crafted motion to dismiss. We then filed a motion to dismiss. I noted to Judge Contreras it might not be well-crafted, but apparently it did the job. That's the factual point. On the law, Bond v. Serrano does not get into whether or not there was prejudice. Bond v. Serrano does not get into any elements of equity. And in fact, the appellant in Bond v. Serrano argued that consideration should be given to where the original suit was filed, whether it gave timely notice to the defendant, whether there was any prejudice to the defendant, and whether the plaintiff had acted reasonably. That was paragraph 1 of the second section of the court's opinion. The second paragraph of section 2. Second paragraph simply says, we've already ruled. Namerity v. General Carr. We're bound by that, we're done. And the opinion quickly ends after that. It's Judge Farrell's concurrence that goes into more detail. In that, Judge Farrell outlines the difference between a statute of limitations and all of the deadline-setting rules upon which the appellants rely. Those rules are set by those deadlines are set by rules. There is a question as to whether or not those deadlines could be equitably tolled. By the same token, there is a question if someone files a notice of appeal to this court late, it could be tolled. However, the statute of limitations is enacted by the DC Council. It is a statute, and as Justice Farrell notes, and as the court has repeatedly said, it is not the purpose of this purview of this court to enact new legislation. So,
If we were to assume, Mr. Mugaber, that equitable tolling, that this court has adopted equitable tolling principles, and one of the issues we look at, one of the factors is a prejudice to your clients, what would you say the prejudice is?
Your Honor, I think to answer directly your question first, the prejudice to the defendants would be that we are entitled to rely upon the statute of limitations. 3 years had passed. The purpose of the statute is to introduce finality, so that no matter what, once a particular deadline has passed in the statute of limitations, the defendant knows it cannot be sued. However, I think Your Honor's got there's an if in your question, and I'm not entirely sure the if is valid, because this court has said that equitable tolling is available in very, very narrow circumstances, lulling, the discovery rule. That's it.
What about Simpson? You say that all of your opponent's cases are about deadlines other than statute of limitations, but Simpson did seem to permit equitable tolling, acknowledging that bond, might reasonably have been read to foreclose it with respect to a statute of limitation, what seems to be worded as a statute of limitations, a 1-year filing requirement.
And actually, the Simpson court found the 1-year statute of limitations did not apply, because the 1-year statute of limitations dealt with claims of discrimination. She wasn't making a claim of discrimination, strictly speaking. What she was doing was challenging a decision of the commission. They also found that the 30-day filing deadline for essentially public employee protection statutes did not apply because she wasn't a public employee. What the Simpson court found was, given the circumstances, the 3-year catch-all statute of limitations applied. The question before the court was, when did that 3 years start to run? And there, I think the Simpson court, although it never directly said it, relied on the discovery rule. She had gone to the Court of Appeals. Everybody agreed the Court of Appeals should have it until everybody changed their mind. She went back until she was lulled and brought back into the commission. Court of Appeals said, you're right, you should go back to the commission. Commission said, I'll take it. No, I won't take it. Back to the Court of Appeals. Everybody agreed the Court of Appeals should have it until the court decided, no, actually we shouldn't, at which point she had to file in the Superior Court. Up to that point, you had not only a pro se plaintiff, but also the District of Columbia with all its lawyers, and the commission with all its lawyers, the Court of Appeals. Everybody seemed to think she was in the right place, at least for a while. The Simpson court, I think, found that's, at least implicitly, that's sufficient to invoke the discovery rule. She didn't know until X date that she had to file in Superior Court. At that point, she had 3 years to do so. And she did file within the 3 years. Whether or not there was some sort of laches argument, that was how, essentially what went down on remand.
I get some of the points you're making as a matter of detail, but more abstractly. And you're right, it was a 3-year catch-all, not the 1-year provision that was at issue. But that's a statute of limitations, and the court said equitable tolling because filed in the wrong court for understandable reasons in sympathetic circumstances, summarized. And I don't think you think that's a fair summary, but if it is, it seems to be hard to reconcile with the idea that there's a flat rule that filing in the wrong court in sufficiently equitable circumstances can toll a statute of limitations, not just a court filing deadline.
I think, Your Honor, at that point, Simpson is an outlier.
Is what?
An outlier, to put it bluntly. It was an extraordinarily unique set of circumstances. It is not the same as Normandy v. General Carr, Curtis v. Aluminum Association, Bond v. Serrano, the other cases that we cite. In those cases, each one of the plaintiffs genuinely, reasonably believed they belong in either the federal court or Maryland court or somewhere. They got a certain distance in that court, were told this court lacks jurisdiction for one reason or another, at least in two of the cases, because of rulings in completely independent cases that came down from the DC Circuit or from the Supreme Court. They then refiled in the District of Columbia. They were caught unawares. They refiled in the District of Columbia in the Superior Court, and this court said there is insufficient basis for any kind of equitable tolling. It doesn't exist in this case. So while Simpson offers a sympathetic image for the appellants here, I don't think it gets them anywhere, because Bond v. Serrano and the other cases control. And equitable tolling because you filed in the federal court when you shouldn't have, even if you did it in good faith, is not the law in the District of Columbia. Turning to the question of the Anti-SLAPP Act, it is, I think Mr. Waxman betrayed his argument here when he said that if there had been a resolution that all American Studies professors should have tenure, there wouldn't be any lawsuit. That's probably precisely right. The problem is that the content of this resolution was so objectionable to those four appellants that they decided to sue the American Studies Association and a number of members of the National Council, the nominating committee, on various counts, simply because they disagreed with the content of the resolution. The American Studies Association has passed numbers of resolutions.
But aren't you now, you're kind of questioning, you're looking at the motivation behind the filing of the lawsuit.
There is a very fine line, Your Honor, and it's difficult to avoid because the purpose of the Anti-SLAPP Act is to stop those very lawsuits which are intended to punish the speaker. That statement of purpose invokes the motivation of the plaintiff, of the suer.
Yeah, but the wording of the statute doesn't, and we said in our earlier opinion in Bronner, I thought that the motivation really wasn't going to be what we were looking to, and what we're going to instead look to is the gravamen of the complaint and the definitions in the act and see how they fit together. So turning to that, taking count one, for example,
Yes, Your Honor.
and focusing on the gravamen, the actus reus and gravamen of the complaint, and the wording of the definition of the statute, and I guess, and also what we said in our earlier decision in this case. What could you just walk me through, like which part of the definition of act in furtherance of in 5501 are you relying on in arguing that count one is covered by the Anti-SLAPP Act?
Okay, in count one, of course, the claim is that the individual candidates and the individual council members misrepresented their intentions to the membership, and they plan to suborn the ASA to advance USA CBI through the adoption of the resolution. I'm sorry, I'm reading off a cheat sheet. And also failed to inform the membership of the projected costs of the resolution. That's count one. The effective, the essence of that claim is that these individuals should not have been nominated to be members of the National Council because they supported, because A, they supported USACBI. B, they intended to advocate for and defend and adopt and then ultimately defend the resolution which supported a BDS movement in Palestine.
Well, I don't read it quite that way. The way I understand the gravamen of that claim is that if you're an officer of an association or running for such a position, you owe a duty of loyalty,
Yes.
a fiduciary obligation to be straight, to be forthcoming about material facts, about matters that would be material to the association. And that given how, what was known about this issue, they should have known that this was material and that their plans with respect to that boycott resolution would be material to those people who were making an assessment about who they were going to vote for.
That is the key point, Your Honor. A material issue. It was not until after the resolution was passed that anybody realized that the resolution itself would be material. There's no evidence. There's no allegation.
Could we wrap back around to the question I was asking you though? Because I am curious about which part of 55.0, which exact words in the definition of act in furtherance of the right of advocacy you are claiming the conduct alleged in count one is covered in virtue of. So like, what are you relying on 1A1, 1A2, 1B? And if you're relying on them, could you explain to me which words you're relying on and how they fit to the allegation in the complaint? If the allegation is understood to be, as I had read it, I think as Judge Ruiz's question suggests, as at least in primary part, so focus on this part, at least for me, if you would, saying these folks were running for internal elective office. They had a duty of, a fiduciary duty to be straight about their plans with respect to something they knew would be controversial or should have known, and they weren't. So if that's the actus reus, which is maybe partly an omission rather than an act, could you just orient me orient that act in the statutory definition of act in furtherance of the right of advocacy on issues of public interest?
Okay. The the answer to both of Your Honor's questions may be a two-parter, but bear with me for a second. The act itself that falls within the statute under count one, and if we're looking at the nominating committee, the nominating committee and the candidate statements, the act, it would be the candidate statements, which are a written or oral statement, in this case probably written, in connection with an issue under consideration. In a place open to the public or public forum in connection with an issue of public interest.
So your argument is that internal statements to the members of the APA is a place open to the public or a public forum. I don't remember seeing that in your brief. Maybe I missed something. I'm not sure it's in the trial court's analysis either. So is and that seems to me to pose a lot of unanswered questions. I don't know off the top of my head whether within the meaning of the statute, the internal communications to members of the organization is a place open to the public or a public forum.
Well, and we get back to the second part. Well, I think given the size of the membership, and given the fact that these are posted on the ASA website, that would be a sufficient public forum. Was that theory ever articulated in those terms to the trial court or in this court? I don't recall having seen it in your brief in this court. It's possible it was in the trial court and I missed it. To be honest, Your Honor, I would have to go back and look at our brief and memoranda. I know that the arguments, the essential argument that we did pose, and I know the trial court focused on the website and its public nature at one point in its opinion. It may not have been with count one. However, the gravamen of count one is that as I said, these individuals should not have been nominated and should not have run, because they supported USACBI. It was the act of Professor Puar as a member of the nominating committee to even put these people up for candidacy that violated her, quote, fiduciary duty, unquote. It was the decision to run, and it was the decision to pack, in the plaintiff's terms, pack the National Council with supporters that breached the fiduciary duty. Getting back to Judge Reese's question.
But that's, if I may just interrupt a second, but that's because the so-called, the packing breached a provision in the bylaws, right? That there should be a representation of the diversity of the membership.
The provision of the bylaws calls for diversity in terms of race, national origin, gender, sexual orientation. One can obviously stretch it to graduate students, tenured professors, adjuncts, etc. It does not, and this is the point I was making about materiality, it does not go to every single aspect of one's opinions. You don't have to put in your candidate statement your opinions on every possible conceivable controversial issue. You don't have to talk about where you stand on veganism and whether Colin Kaepernick should take a knee, and whether or not Black Lives Matter, and whether or not I'm running out. I mean, the list is endless, but
this was pretty
this was
central.
only material after the fact. That's the point. There is no allegation and there is no evidence to suggest that before these individuals ran for office, before they were elected, or before the resolution was actually put forward to the membership.
But that would probably be a subject of inquiry under step 2, the likelihood of success on the merits, correct? Not whether there's been a prima facie case made.
Well, the prima facie case, yes, I think you're absolutely right, Your Honor. The prima facie case would be, does it relate to an act, an expression of public opinion, or, excuse me, an expression on an issue of public interest in a public forum? And I think the candidate.
And we've been talking about whether these statements or omissions were in a public forum.
Right, and I would also note that in the complaint, a great deal of the opposition of the background information involves articles written by these professors, books published by these professors, lectures given by these professors, and how those statements out in the public betray their actual prejudice, their actual bias.
Can you help me shifting from count 1 to counts 10 and 11?
Sure.
And can you walk me through briefly how, under the relevant statutory definitions in light of the allegations in 10 and 11, you think the conduct there, and there really may be, I mean, the encyclopedia and the non-publication of the encyclopedia seems like maybe the easier piece of that for you, although, but focusing, for example, on the termination of Mr. Bronner. How can you explain to me how that fits under the statutory definitions that would make it covered by the Anti-SLAPP Act?
Absolutely. First of all, Your Honor, the way the complaint is drafted, the allegedly only reason for the non-renewal of the contract, not termination, non-renewal, is because Professor Bronner opposed the resolution, and the defendants, who may or may not have been on the National Council at the time, advocated for the resolution and supported the resolution. It was that specific difference of opinion, as expressed through not only public statements, but also a complaint filed in the federal court, that was the reason for the non-renewal of the contract. I would also note, and this
I get that, but I'm still waiting, I guess, for how that fits under the statutory definition.
statutory of anti-SLAPP.
Yeah, the definition
yes.
acting furtherance of the right of advocacy. So if the claim is, I'm being, I'm an employer. I'm being fired. I'm being sued because I fired somebody. That's this claim is, That's the act, firing somebody. And your position is that's covered by anti-SLAPP because ... looking at the wording of the definition of what makes something an act in furtherance of. Why is firing somebody, when, if ever, is firing somebody an act in furtherance of the right of advocacy using the statutory definitions, not just sort of saying, well, there's an advocacy context to it, but actually trying to zero in on the wording of the statute?
Well, it depends on why you fire them. If you fire them because
Where in the statute does it suggest that it depends on why you fire them? What statutory term are you relying on to say that?
Arising out of an act arising out of a written or oral statement in a public forum in connection with an issue of public interest.
So you're saying the firing.
I'm saying, Your Honor, if I terminate an employee because he attended a Black Lives Matters rally, and that's the reason, then the termination arises out of his expression of advocacy in a public forum.
Right, but the statute is not worded that way. The statute requires that as we've interpreted it, I think requires that the act that is alleged to be unlawful, which is the firing, has to be an act in furtherance of. And so, how is the firing an act in furtherance of the right of advocacy? It's not that the act, someone is being sued for an act that was in response to advocacy. That's not the way the statute is worded. It has to be, as we've interpreted it, the claim has to arise out of, in the sense of, it's the subject of the complaint or an element of the claim. And so if the claim is firing, unlawful firing, how does the act of firing constitute an act in furtherance of? It's not a written or oral statement. I wouldn't think. Maybe you think that it's kind of a performative inference in philosophical terms, but
if I may, Your Honor, what this court said in the last time we were up here, the party's statutorily protected activity must itself be the basis for that party's asserted liability. In the case of the firing, it's somewhat turned around because you as the employer would not be suing. You as the employer would be sued.
Understood. That's why I'm wondering whether it's covered.
Well, well, yes. But the underlying reason for the termination, the marching in a Black Lives Matter rally, is the basis for the termination and thus the basis for the employer's asserted liability. Therefore, in that instance, the termination would arise out of the marching in the Black Lives Matter rally, and therefore would fall under anti-SLAPP. By converse, if I fired somebody because they kept showing up late every day, you're absolutely right. That doesn't fall under anti-SLAPP. That's got nothing to do with speech. One more point, if I may.
But just to be clear, if you think that if I'm an employer and my employer is supposed to be at work all day, and my employer instead goes and spends all 8 hours of the workday giving a statement on a matter of public concern, and I fire my employee because I actually would like my employee to be doing work,
Sure.
You would say that lawsuit would be covered by the Anti-SLAPP Act.
It would meet the first prong of the act. It would arise out of. However, in that instance, I think.
Just to be clear, though, I mean, the problem I'm having is that to a degree, your answers seem to be merging together two things. 5502 requires that the claim arise out of an act.
Mm-hmm.
The definition of act doesn't have any word about arise. It doesn't have the word arise in it. There's a definition of what constitutes an act in furtherance of, and that requires that it be a written or oral statement in certain circumstances, which I wouldn't think firing would lead to mind as, but maybe you could argue it was. Or it would require an expression or expressive conduct of other kind. So it's that act that the act that is the basis for liability that it doesn't have to arise out of advocacy. The act has to itself be a written or oral statement or another expression or expressive conduct.
Right.
Unless I'm off.
No, and what I'm saying, Your Honor, is in the hypothetical we've been working on, attending the rally for 8 hours would be an act of, and again, I'm getting the words wrong, but essentially an expression in a public forum.
Right, but nobody's holding the employer. Nobody's trying to hold the employer liable for that expressive conduct. Somebody's trying to hold the employer liable for firing the employee.
Right. Okay. And in this, given the hypothetical, it might be a little more convoluted. But I would say that it may meet the first prong, but certainly, given that the employee was supposed to be at work for 8 hours and instead was at the rally and he didn't get his work done, that would be sufficient to meet the second prong if in fact there was a modicum of evidence in the record. I would note on count 10, it is not just the non-renewal of the contract. Professor Bronner is seeking punitive damages because of false and defamatory statements that the individual defendants made about him during the course of the decisions not to renew the contract. If nothing else, that brings it within the concept, the context of the anti-SLAPP, at least for the first prong. Turning to the second prong, if I may for a moment, and I have no idea how much time I don't have left, so
Turn to the second prong quickly.
yes, absolutely, Your Honor. Turning to the second prong, this court has said repeatedly that the anti-SLAPP is more akin to a summary judgment. And in fact, this court, the last time we were up in front of this court, the court said that if all you did was look at the allegations in the complaint, it would be no different than a 12b6. And that's simply not the case. So, plaintiffs knew they had to put forward some evidence. Plaintiffs put forward no evidence whatsoever. They claim that we admitted to the number of quotes and excerpts were valid. That's not the case. What we admitted at most was that those words were contained within a document authored by the person who allegedly said it. We did not admit to the interpretation given to it by the plaintiffs. Given the number of misstatements throughout the record by the plaintiffs, I think that's a material point. The last point on that is that with the exception of some of the emails regarding the non-renewal of the editorial contract, all of the emails they quote all relate to the actions taken in 2012 and 2013. Those actions are time barred for the reasons we've discussed. It doesn't matter how much evidence you put forward on a claim if it's time barred. It's time barred. There is no hope of success in the merits. What is missing, and the crux of this entire complaint, according to the plaintiffs, is money has been wasted. What is completely missing from the record is any evidence at all of the finances. They have allegations of what's been spent. They have allegations that massive withdrawals were made. They don't have an income expense statement. They don't have the budget for a particular year. They don't even have the Form 990s, which are publicly available on GuideStar. To the extent that they're trying to show breach of fiduciary duty by misuse of funds or corporate waste or any of those other claims, there's no evidence whatsoever in the record. With that, unless the court has any questions, I will turn it over to Ms. LaHood.
Thank you very much, Ms. LaHood. We'll hear from you.
Good morning, Your Honor. Maria LaHood for Appellee Saleda. There are two allegations against Dr. Saleda: that he advocated for the ASA resolution to endorse a boycott of Israeli academic institutions, and that he served on the National Council from July 2015 through June 2018, long after the resolution had been passed. Most of plaintiff's claims against Dr. Saleda are from before he joined the National Council, when his advocacy for the resolution is the only factual allegation against him, and therefore the only possible basis for his asserted liability. His advocacy is protected as communicating views to members of the public in connection with an issue of public interest. Plaintiffs don't appeal the anti-SLAPP dismissal of counts 1 and 4 against Dr. Saleda, which allege acts leading up to the resolution, so are based on his advocacy for it. The same protected advocacy is the basis of counts 3, 5, 11, and 12, and the claims in counts 2 and 9 that precede the resolution and Dr. Salida's national council tenure. Count 3 relates to the nominations preceding the resolution. In plaintiff's reply at page 12, they claim count 3 alleges Dr. Salida provided substantial assistance in passing the resolution. Otherwise, there's no, so basically confirming that's the reason for the claim. Count 5 relates to influencing legislation through June 2015, before Dr. Salida was on the National Council. Legislative advocacy is covered under the Anti-SLAPP Act under 1A1 and 1B. In count 11, Mr. Bronner explicitly alleges that Dr. Salida could only be liable for tortious interference before he joined the National Council and was a fiduciary. There were also the statements that were mentioned earlier that they claimed, several defendants make, although they don't attribute them to Dr. Salida, that spread false and pejorative misstatements that were widely shared inside and outside the National Council because of Mr. Bronner's opposition to the resolution and his undermining of the ASA. Those statements are also covered as statements in a place open to the public or in a public forum, and expression that involves communicating views to members of
They'd
the
be covered only if they were also matters of public interest, which I depending on what they were, they might or might not be.
Your Honor, this court in Saudi American Public Relations Affairs Committee found that statements in connection with an issue of public interest should be generously construed to advance the goal of the statute to deter SLAPPs, and that a statement may relate to the public interest as long as it's not directed primarily at a private interest. And in that case, even though the statements mostly focused on the plaintiff as an individual, they were made in the context of a quote, firestorm between two competing Middle East special interest groups and appear to have been fueled by differing policy views and their apparent purpose to discredit plaintiffs and to elevate defendants in the larger policy debate. So that's basically exactly what plaintiff is claiming.
So your answer is yes, they would have to be, but you think they would be.
I think they are, yes.
Ms. LaHood, I'd like to ask more about the legislative advocacy part.
Mhm.
Because as you say, that sounds like it would be covered under the protected under,
Right.
you could make out the prima facie case under the Anti-SLAPP Act. But then you go on to the second step,
Mhm.
right? Which is nonetheless, can the plaintiff show a likelihood of success, right? When you're dealing with a nonprofit corporation with a certain tax status, which limits its lobbying activities. And again, I understand the dates and I'm just
Right.
thinking more at a theoretical level. Is that the point at which the plaintiff is able to say, yes, this might be covered under the Anti-SLAPP Act? You have made out your prima facie case. However, as an officer of this corporation, you have to abide by the bylaws. And there's a good reason for this. And so you could not engage in that kind of activity. Is that the way to think of how this would
That's
play out?
exactly right, Your Honor. And I think plaintiffs concede as much when they argue that their claim is that the ASA did too much legislative influencing or too much lobbying. They're conceding that the claim is based on legislative advocacy. And when you get to prong two.
Well, that's a prong two issue.
Yeah, well, they're conceding that it's based on legislative advocacy. They're just arguing it's too much. And that's the
right.
prong two issue.
Because it
Right.
exceeded the whatever, I can't remember the.
Substantial part of
Right.
activities.
Thank you.
That's right, Your Honor. And then returning to count 12 for aiding and abetting a breach of fiduciary duty, plaintiffs explicitly state that it's brought against Dr. Salida for his efforts to pass the ASA resolution before he was on the member of the National Council. That's what the Superior Court found. Plaintiffs conceded it in their opposition to their first motion to dismiss, contrary to their argument now that it's for the time period when he was on the National Council. As for the claims in count 2 and 9 that precede Dr. Salida's tenure, they all arise from his advocacy for the resolution as well. And I can talk more about the details of those claims against others when I get to that. So each of these claims satisfy the first prong of the Anti-SLAPP Act. They're also not likely to succeed on the merits against Dr. Salida. Each of these claims are time barred against Dr. Salida because they're for acts prior to 2015. When plaintiffs first sued Dr. Salida in federal court in their second amended complaint on March 6, 2018, the statute of limitations had already run for any claims before March 16th, 2015. That includes all the resolution claims. There's absolutely no argument that equitable tolling is available for those claims against Dr. Salida. I don't want to wade into the equitable tolling, therefore, but just to supplement, when Your Honor's asked about prejudice, the purpose of the Anti-SLAPP Act is to deter harassing lawsuits and provide for prompt dismissal. If equitable tolling were to apply, and fairness is a consideration in deciding whether equitable tolling applies, one could file a case in federal court to avoid application of DC's Anti-SLAPP Act, and that would simply elongate the harassing litigation, keeping it over defendants' heads for even more years. Just another area that doesn't apply to Dr. Salida, but I don't think it was mentioned that when plaintiffs filed their case, they knew they didn't have derivative claims because they didn't file the required notice 90 days in advance. They also knew what damages they were alleging individually. So they knew they didn't have a sufficient claim of damages for diversity jurisdiction. So that was the time bar issue. They're time barred, and the discovery rule doesn't apply to claims against Dr. Salida since plaintiffs have known of Dr. Salida's advocacy for the resolution since at least 2014, when he publicly acknowledged it in an op-ed, which they excerpt in their complaint. Moreover, plaintiffs didn't allege Dr. Salida was personally involved in any of the actions that form the basis of the counts against him. And because these claims arise prior to his national counsel tenure, he owed no fiduciary duty, he couldn't have acted ultra vires, and he was not bound by any contract. There are additional arguments for 11 and 12, but they're all time barred. So for the only claims against Dr. Salida from his tenure on the National Council are the remaining parts of 2 and 9 and count 10. Counts 2 and 9 alleged the withdrawal of ASA trust fund assets was tortious because the funds were used to enact, support, or defend the resolution. As this court suggested in Bronner, because count 9 alleges that the use of funds to declare the resolution enacted amounts to corporate waste, count 9 appears to be based on the resolution and so is covered by the Anti-SLAPP Act, or would be covered. This is similarly true for funds to use to support, defend, or enforce the resolution, and is also true for count 2 regarding misuse of assets. If the funds weren't used in relation to the resolution, under plaintiff's own theory, they wouldn't state claims for misuse of assets or corporate waste. If you look at the—
To make sure I understand how broadly you're making this last point, if the allegation had been that a hypothetical additional defendant had secretly taken money from the ASA and had used it to, I don't know, bribe compliant journalists to write, favorable stories about the ASA's adoption or alleged adoption of the resolution, would you say, a claim of embezzlement, misappropriation would be covered by the Anti-SLAPP Act because it's, again, going back to the definitions, you would take the taking of the money and the expenditure of it for that purpose to be expressive conduct that involved the resolution, or how?
Bribery is an interesting question, Your Honor. I hadn't thought of bribery. What I was thinking was plaintiffs here don't allege any other basis of liability. They don't allege that the money was withdrawn without authorization, that it was taken without procedure, if it was procedural improper in any way. They don't say anything about the withdrawal of funds itself. And the Anti-SLAPP Act would not apply if money were embezzled or taken for personal use, even if the funds were then used for protected activity, because the claim is stated regardless of what the money was used for. If it was used for a jet plane or if it was used to publish a book, there's still a claim, and it's not, the basis of it isn't protected activity. So if, in your question.
Well, I mean, it is, if it's to publish a book, it's expressive activity.
Right.
The reason it's not covered is because I'm guessing is because you don't think, I'm not sure quite why, because the connection between the wrongful nature of the conduct and the expressive nature of the claim is too attenuated? Or
No.
how exactly would you
Because
articulate
the reason the reason in the hypothetical case, the improper use is personal use, not, and so it doesn't matter if it's protected activity. Let me give an example just with count 5 or count 9, sorry. So the essence of a waste claim under Daly is the diversion of corporate assets for improper purposes.
so just one of the ways of thinking that your opponent was advocating about the waste count was think of it as independent of the content or viewpoint or either of the resolution, and think of it as they're spending money to defend a resolution that was not properly enacted. So that, you know, who cares what the resolution said? It could have said anything. The argument is this is an unenacted resolution and you're wasting money pretending that it is, and don't care what it says.
So
Wouldn't that on your line of thinking not be covered?
they are, first of all, they're getting to prong 2 when they're saying, no, but it was illegal. Nothing in the DC Council's Anti-SLAPP Act says anything about content or viewpoint, except to the extent that it needs to be on an issue of public interest. Nothing that this court, no precedent that this court has said has anything to do with content or with viewpoint. In fact, I think getting into motivation at all, we've already said we can't do. So because you don't look to content or viewpoint, it is that it's based on a statement. It's based on the resolution. They've actually in their brief, they acknowledged in their reply, what they claim is the resolution was wasteful. Yes, they say because it was passed illegally, but that's a prong 2 question.
So I understand the line of thinking. I'm not sure I fully accept all of it yet, but so imagine that the head of an organization using a business credit card that the head of the organization is entitled to use, takes that money, uses that credit card and buys media time and puts out a statement. And on a matter of public concern, hypothetical 1A says, I just want to announce to everybody that I'm running for senator. So public interest, matter of public concern, covered by the Anti-SLAPP Act or not? If the allegation is that was, misappropriation of funds, breach of fiduciary duty.
So in that example, Your Honor, I would say the actual claim is that they used money for personal use, and
how
that's
do you
why it
know
was
that
improper.
independent of the content of the statement?
Well, what I'm saying is you might know it from the content, but you'd also know it if they, bought a ticket to Hawaii for personal use. The claim that they used the money, improperly is based on the fact that they weren't supposed to use it for personal use. So it doesn't matter what they used it for. That's not the subject of the claim. The subject of the claim is that they used it for personal use.
At the highest level of
inappropriately.
abstraction, that's your opponent's argument seems analogous. It is these folks, they took corporate assets or organizational assets and they made personal statements and are passing them off as statements by the organization itself, when that was, on their view, procedurally irregular, not in the interest of the organization and the like. And the only way you know whether that's right or not right is to look at the content of what was said.
I disagree that they claim that they were for personal use. They claim they used the organization to make statements that they argue are not in line with the mission of the ASA, but they made them on behalf of the ASA. Nothing is alleged to be, they say they were in the interest, maybe in the personal interest of people because people are interested in an issue of public interest, but they don't claim that they were personal statements.
But
They were
what
statements
about-
of the ASA.
I'm sorry, but what about the procedural irregularity of the claimed procedural irregularity of the vote?
None of that applies to Dr. Salida, Your Honor. He had no involvement.
No, but regardless of whether he was involved or not involved, the question is whether the resolution was in fact a statement of the organization.
Regardless of whether it was void or illegal, as they say, the statement was a statement of the ASA, and that is the subject of the claim. They can argue whatever they want when they get to prong 2. But the subject of this This claim, this misuse of assets claim and this corporate waste claim is that the money was inappropriately spent because it was spent on the resolution.
And just if the hypothetical I gave was a little bit different, so that the organization, the head of the organization took the business card of the organization, which the head is generally allowed to use for business purposes, organizational purposes, and buys media time and says, my organization wants to announce that I'm running for senator. And there's a claim that that is corporate waste or organizational waste or breach of fiduciary duty. So it's it is a statement, it's the head of the organization on behalf of the organization saying, here's a thing. If you look at the content of it, one could reasonably argue that has nothing to do with the organization. That is all about you taking the organization's assets and using it for your own, to advance your own personal agenda. Would you say covered or not covered?
I think it is, I think there's an argument that it could be covered, but that's not the argument we're making. The argument we're making is that there's a separate violation. They're not supposed to use, first of all, if they're a nonprofit, they're not supposed to be doing any political as in election activity. So there will be other claims, and that would be the subject of the claim. And I guess if that's the subject of the claim, that's why it was improper, maybe. Or if it's just because they shouldn't have used it for personal use, you don't need to get what it's used for. It could have been any kind of personal use. So I guess it depends on the claim, but here in this case, there's claim of misuse of funds because they were used on the resolution, and the resolution, as this court found and as plaintiffs have not contested, is protected activity. So
I'm sorry, so going back then to the lobby, you say, well, political activity, that's just all out, right? You can't do that. And on the lobbying, you distinguish because it's a matter of degree, but
No.
what if it had been, okay.
sorry, when I said political activity, I meant like election
No, I
activity.
understand.
So because count 5 is that they're claiming that they did too much legislative advocacy. First of all, legislative advocacy is not prohibited by a nonprofit. You can't do more than a substantial part of your activity. So it's, first of all, what claim could fall under legislative advocacy, but that is the actual claim that they are engaging in legislative advocacy, clearly covered. Fine, move on to prong 2, allege, which they don't do, proffer evidence, which they don't do, that there is too much, that more than a substantial part. Again, this claim doesn't even apply to Dr. Salida, so I want to be cautious, but that's how I'm thinking about it. So that's for 2 and 9. Why we allege 2 and 9 satisfy or come from protected activity. There's other reasons. I think that is our primary reason. One of the things that they allege, and actually the only thing they allege was spent during Dr. Salida's tenure, was defending the case against the ASA, this very litigation. And so those litigation expenses would be covered as expressive conduct that involves petitioning the government. They could also come under 1A1 as well. I don't think you even need to get into the question of funding, whether it's funding litigation, although that has been found to be covered under California's Anti-SLAPP Act. And whether it's speech, even if it costs money, we argue it does, but I don't think you even need to reach that issue. And then for count 10, again, Bronner claims that defendants breached their fiduciary by spreading false information that they widely shared. So the same thing as count 11. We've already mentioned the not publishing additional entries on the public online encyclopedia, which would be covered. And
Assuming its contents are an issue of public interest?
yeah, I think, Your Honor, that if it's about American studies, which is what the encyclopedia is, that is an issue of public interest. And plaintiffs had argued that argument was waived. It was not waived. We've raised it all along in all of our briefs. I want to say non-renewal. First of all, non-renewal is not a claim made against Dr. Salida. In fact, in the bylaws that are attached to the complaint, they say that the decision whether, who to designate for the encyclopedia editor is made by the executive committee, which Dr. Salida is not on. So this doesn't apply to Dr. Salida. Again, I don't necessarily want to wade into it, but I think there could be an argument that deciding not to renew the contract of a consultant who has sued the ASA, who has withdrawn their institutional department from the ASA, is possibly expressive conduct, communicating views to members of the public, that that's not an appropriate thing to do and to remain or to get your contract renewed. Again, it's not an argument that we need to make because it's not an allegation against Dr. Salida. So as far as unlikely to succeed for these last counts 2 and 9, again, the decisions to withdraw funds from the trust fund are made by a separate board of trustees on which Dr. Salida did not sit. And that's in the bylaws that are attached to the complaint. So
And not subject to the any kind of supervisory obligations of the National Council?
there might be I would have to look to see if there were a review by the National Council, but there's no allegation that Dr. Salida had anything to do with the use of funds or decisions around the use of funds from the trust fund or otherwise. And there are various other ways in which 2 and 9 fail. That's in our brief. I already mentioned that count 10 fails because it's the executive committee who makes decisions about the encyclopedia editor, and there's no allegation that he made any decisions about what goes up on the website. So none of plaintiffs' claims can succeed against Dr. Salida, and they all fall under the Anti-SLAPP Act. Dr. Salida was sued for his boycott advocacy of dozens of National Council members who joined after the resolution was passed. He is the only one who was sued. The purpose of the Anti-SLAPP Act is to deter lawsuits just like this one that abuse the court system to chill advocacy on issues of public interest. So the court should affirm dismissal of plaintiff's claims against Dr. Salida. Thank you.
Thank you, Ms. LaHood. Mr. Is it Kleiman?
Yes, it is Kleiman, Your Honor. Thank you.
Kleiman?
I had not been intending to start here, but let me dive into the question of the 10th and 11th causes of action here. And some of this was raised by my colleague, Ms. LaHood. If Dr. Bronner had been an IT specialist or had been an accountant, I think we'd be having a very, very different discussion than we need to have right now. If you think of the encyclopedia, which is the major annual publication of this organization, an organization which, by the way, is, because of the nature of its subject matter, right at the dead center of all of these debates about DEI and structural racism and all of this sort of thing. The ASA is essentially in the position akin to a publisher. And the publisher gets to decide who the editors are going to be and what they're going to do to speak for that publication. I don't think we have to get into the question of whether a firing would be legal or illegal under other circumstances, because under these unique circumstances, where Dr. Bronner was in a position to publish in the name of the organization, yes, the organization gets a vote in that. I want to briefly address one other general issue and then talk about a couple of things specific to my my clients. There's been discussion about whether or not there ought to be some sort of equitable tolling provision to soften the effect of a time bar. There are a number of states that actually have statutes that are saving statutes. And where a case has been dismissed by a federal court, those states have provisions that specifically allow refiling. The District of Columbia is somewhat unique in that it does not have a statute like that. So I think essentially the plaintiffs are asking this court to do what they don't want done in other circumstances, which is to essentially create a law and create an exception that otherwise does not exist. If I may, for a moment, I want to talk about the question of evidence and the question of proffers that had been raised before, and specifically with respect to one of my two clients, Dr. Kawanui. There's been discussion about whether or not speech or non-speech about somebody's political principles and agenda can be material when it becomes material, etc. What's unique here is that the plaintiffs themselves admit that Dr. Kawanui had in her candidate statement that she was on the advisory committee of something called the United States Academic Committee for the Boycott of Israel. That appears at JA 54 in paragraph 67 of their complaint, and it appears at JA 62, 63 at paragraphs 24 and 90 of their amended complaint. So the question, I mean, basically, as I understand it, what the plaintiffs are saying is that she wasn't, it's not that she was sneaky or concealing things, she wasn't loud enough. And as one of my colleagues had pointed out, counsel for the ASA, there are an awful lot of things that can be addressed in the finite space of a candidate statement. And both the shortness of attention and the brevity of candidate statements in general prohibit somebody from essentially writing their life story about everything they believe in that statement. Dr. Kawanui said she was doing this. So to advance the claim that this had been concealed is, given the fact that the plaintiffs admitted in their complaint, is factually incorrect. Here is why I think this matters in terms of the questions that this court has been asking about proffers and evidence. One of the claims that the plaintiffs make is that because their allegations should be credited simply as their allegations, because after all, some of the things they said were either admitted in an answer or at least not rebutted in an answer. I'm unaware of any case in the district that suggests that the failure to rebut something constitutes an admission. Be that as it may, the history here matters. Like Dr. Salaita, Dr. Kawanui and Dr. Puar came in, if not the third act, at least the second act of this picture. They never answered the complaint because that had all, the ASA had answered, and the individual professors represented by the ASA had answered. The reason Dr. Puar and Dr. Kawanui hadn't answered it is they were added to the complaint later in 2018. And then there were, the subject matter wars were already at issue. So my two clients cannot be held to anything that another defendant has answered with respect to its complaint. It's important, I think, to note that while this complaint was sitting before the district court, there was, and it was before my time, happily, apparently fairly vigorous discovery, none of which got to the point of actually authenticating any of the documents, nor in the face of this objection having been raised both before Judge Rigsby and before this court on the first time around. The plaintiffs never scrupled to request additional discovery, which is permitted under the DC statute. If they had wanted to get admissions regarding the authenticity of a document or the interpretation of a document, they were certainly at liberty to do so. For them to come in now, I would say it's not even the third act. I think the audience is getting ready to leave the theater. For them to come in now and say, wait, we'd like to do this over, is time barred. With that, I will stop. The shortness of human life argues that we should thank the court for its patience.
Thank you very much, and take care of yourself.
Thank you.
Mr. Waxman will give you 3 minutes for rebuttal.
Okay, I will try to be extraordinarily concise. First, on the statute of limitations, Judge McLeese, on the issue of the distinguishability of Mathis, which was decided under DC Rule 15. That rule has long since been incorporated in the DC Code under Section 2-510A. And in that respect, I think is indistinguishable from Simpson and from this case. In the Curtis case, which you mentioned, we addressed this at page 3 of our reply. Curtis's holding was that bond was, quote, binding because there was, quote, no significant distinction between the circumstances of it and bond, which of course suggests that if the outcome might have been different, if the circumstances were different. With respect to equitable tolling, our submission is that Judge Rigsby erred when he unquestionably held that equitable tolling is categorically barred when the reason for missing the statute of limitations is filing in the wrong court. And it would be a very strange rule in significant tension with our federal system if anytime you invoke federal jurisdiction, but you can conceive of a possibility that the court might not find subject matter jurisdiction at some point along the way, you also sue in the DC Superior Court or a state court and say, you can put this on your docket. I'm really sorry about your statistics, but you don't need to do anything because we're actually litigating this case in another court. On step 1, Judge McLeese, I think we were talking about the difference between the California statute and the DC statute, and I was pointing to the language of the act in furtherance of. In your opinion, I think in this case, you pointed out that the significant distinction is, I hope I have the right page here. The significant distinction was the change in the definition in 5501 of what an act in furtherance of was, and where it had been, whatever the language was, it then was substituted for expression. That is, an act in furtherance of must itself be speech or an expression, not only any other act. The argument made by one of my friends that, the obvious reason for count 10 is that, it was fine to terminate Professor Bronner because he'd already sued the association. That's just factually incorrect. He was terminated years before this lawsuit was filed. On step 2, the argument is that the only, whether we're right that attaching emails and quoting emails and other statements, constitutes the proffer of evidence. There's nothing in the complaint after the so-called nomination periods. That's just wrong. I mean, you can look at paragraphs 172 to 185 just as an example of allegations that occurred even as to defendant Salaita long after the fact with respect to corporate waste and, and other statements.
They
And
mentioned the lack of any kind of financial statements.
Sure,
as to- on the waste issue.
yeah, paragraphs, I think this may not be it, but paragraphs 172 to 185. In fact, they quote what's on the Form 990s in part to show this decrease in revenues and the expenditures spent in violation of the charter and jeopardizing its tax exempt status. I want to be clear about defendant Salaita. We are not pursuing appeal of the dismissal on counts 1, 3, and 4 because we concede that we cannot survive a 12B6 motion to dismiss. We do not concede that defendant Salaita could make out a slap claim because we think as to each of those claims, step 1 cannot be satisfied as to defendant Salaita, just as to all the other defendants in the case. As to the other claims with respect to defendant Salaita, to the extent that they are relying on a claim that those other counts don't, in those other counts, they have met their prima facie case, our answer with respect to defendant Salaita is the same as with respect to all the defendants, as it has to be, because the step 1 inquiry is not defendant specific. If their argument is that we will not be able to meet our burden, well, there would be no step 2, therefore. If their argument is we haven't alleged enough to state a claim, then the counts will be dismissed under 12B6. I do want to say that with respect to the contention by Mr. Salaita's counsel that count 5 certainly can't be maintained because all of the quote substantial devotion of resources and time to influencing legislation predated his election to the National Council is just wrong. You can look at paragraph 175 and see that the allegations relate to expenditures in furtherance of advocacy substantially after he was on the council. The notion that we have not alleged that our corporate waste, breach of fiduciary duty, et cetera, claims, ultra vires claims, don't depend on an allegation that the defendants did these things and spent these funds for, to advance their own personal agendas. The complaint, if nothing else, is replete with those allegations. And the notion that the assertion from my friend, Mr. Kleiman, that there has been vigorous discovery in the case, which I think bears on, I don't know whether the substance of what we have proffered represents, such a ought to counsel for the summary judgment standard. That is totally untrue. Before this case was dismissed, we were able to take one and only one deposition, and that was of Mr. Stevens as a 30B6 witness. There is a lot more discovery coming if the court permits us to litigate our claims on the merits. I don't. Oh, yes, right. So one of the questions was, I'm trying to remember what, I think it was Mr. Mugero basically said, well, as to count 1, for example, there has to be, they had no reason to know that their plan to get the organization to enact a resolution was material. I mean, I would point the court to the emails that are referenced in pages 54 and 55 of the joint appendix, and the allegations in the complaint, again, supported that they knew at the time these people were nominated that there already had been an effort to get support among the 4,000 members of the association for an academic boycott. Under their assertion, 20% of the membership supported a boycott. We will prove that the number was actually 10%. And you look at these emails, they are specifically saying we shouldn't be talking about our plans with respect to a resolution because we need to get in there and have enough, force before we bring this to the fore. I mean, the emails are, there's a reason why they have not wanted us to include, that they objected to us including even the texts of these emails in a sealed complaint, which is the view that, and the discussion back and forth is, well, is that really, is it consistent? Can we really conceal this? And the answer is we can conceal it because the long-term objective is to get enough people on the council that we can get this done. Thank you.
Thank you, Mr. Wax. Thanks to all of the lawyers today for your briefing and your very interesting arguments. The case will be submitted. And I don't think I'm telling you something wrong if I tell you all online that you can log off.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Second case on this morning's calendar is number 23 CF 389 DAIQUON GREER versus United States. Whenever you're ready.
Good morning, almost good afternoon. If I may reserve 3 minutes for rebuttal.
Sure.
My name is Sweta Patel. I represent appellant DAIQUON GREER. Judge Pasachow clearly erred in ruling that there was reasonable suspicion to seize Mr. Greer and search him. A finding is clearly erroneous when, although there may be evidence to support it, the reviewing court on the entire evidence is left with the definite and firm conviction that the mistake has been committed. Hawkins v. State, this court also had the ability, as clear and erroneous standard does not relieve the court of their obligation to conscientiously review the trial court's finding based on the record presented.
Well, I agree with that, but it is interesting that in the discussion among the court and the parties in this case, there was a discussion of the idea that we might not be seeing everything in the video, and that if the trial judge credits the officer's testimony, and the officer's testimony was that I saw this L-shaped, object under the shirt, how do we get, I understand your point that we have to review, this is de novo, we have to review overall the question, look at everything in the record, but how do we treat that credibility determination?
Yes, Your Honor, first of all, the testimony by Officer Green in the transcripts that is in the record is that there was body-worn camera that was submitted, and there was also photos that he testified to and pointed to as to what he observed and what he points to as creases or where he sees an L-shaped bulge. There's no testimony before the court that Judge Pasachow had to consider that. There's zero testimony where the officer says, what I see on body worn camera or what I see on this photo is not what it looked like in real life. In fact, it's the contrary. He actually says, this is the bulge. This is what I see. So the court can objectively look at exactly what Judge Passes saw, exactly what the officer was also.
Is it possible, though, that even though he says that, he's still seeing something we don't see because we don't know what to look for?
But Your Honor, that is a subjective opinion, and this court does have to look at what the officer's testimony is and what he is purporting to be a particular thing with an objective view. And if that subjective opinion of that crease or that bulge that he believes is a firearm or a gun, then it also has to be looked at with other innocent things that an individual may have. And that is a subjective opinion. Even with his training and knowledge, it still has to be looked at with other innocent possessions.
Can I make sure I exactly what the transcript in your view says about that? So I understood you a minute ago to say there's no point in the transcript where Officer Green says, well, I'm looking at these photos now and I can tell that you can't really see a bulge, but they don't really show everything I saw. So I get that. Was there affirmative testimony that the photos had exactly the information he was able to visually see, so that he's saying, yes, that's exactly what I saw. Here's where the L shape is. Or is your point more one of omission, or is it actually that the officer expressly said, you look at that photo, you look at that body worn camera footage, you will see exactly what I saw. And so I'm not adding anything. I am just telling you what I saw and what you can see.
The testimony before the court, the officer does not affirmatively say, this is exactly what I saw in real life or didn't see. However, he is answering questions that's proposed to him as to where the bulge is, what he sees, and he's saying, this is the bulge, this is the crease, this is the shape where the gun is. And
With
so-
reference to what we are able to see.
Yes,
Okay.
there's other.
Well, can I just clarify on that? Several of the pictures had the shirt pulled up. And is it fair to say that when the time period at which Officer Green says he perceived this L-shaped bulge, it was when Mr. Greer had his shirt over that area. Is that right?
Yes.
And so when they were looking, it's hard to tell exactly what exhibits were being used at the suppression hearing, but when they were going through was that acknowledged when the Officer Green was testifying about the photos, because those were actually quite different?
Yes, it was acknowledged. It was in arguments by both sides that the photos that are in exhibit is not exactly the same viewpoint of the officer because there was a shirt covering it. So we would submit that he actually would have had a less of a viewpoint, and it was hidden with another T-shirt, which is actually not depicted in the photos that the court has. The other observations that the officer made also are subject to review by this court because they are depicted, and does not change the fact that this court can still make an objective finding. One of the factors that the government relies on is evidence of blading. Well, let me actually take that back.
Before you get into the other factors, can I just clarify one thing? So I take your point, your argument that to the extent the trial court found as a matter of fact that the officer credited the officer's testimony. I'm looking at this person, I see an L-shaped gun, an L-shaped bulge in the waist area. You're saying to the extent the trial court credited that testimony, that was clearly erroneous in light of the other information that's also available to us, namely the photos about what happened. I think all the photos are after. And then also the body worn camera footage. So I take that argument, but assume for a moment that we take as a given that is not a clearly erroneous finding. Are you contesting that if that finding remains in place, that there was reasonable articulable suspicion at the moment the officer saw that, assuming again that it's not clearly erroneous to conclude that the officer did? Or are you contesting, is your argument about no reasonable articulable suspicion turn in part on or depend on your point about that factual finding being clearly erroneous?
Your Honor, as to your first question regarding if we are conceding to, if the officer in this court credits the testimony that was there and that the factual findings of the lower court of the L-shaped bulge would be sufficient for reasonable suspicion in this case for further search and search of Mr. Greer, we are not conceding to that. In fact, Your Honor, Singleton, I know, goes a lot into bulge in this district and that it has to be more particularized. But Singleton also cites to another case out of a different state, the Supreme Court of Colorado. And that one is People v. Montea, 828 P2D 251, 1992. Well, this is an older case. We would also say that in 30 years, the shape of a gun has not changed. In this case, the officer noticed a bulge that resembled not just an L-shaped bulge, but a very specific .25 caliber automatic pistol protruding from the defendant's pocket. I would say that this is even more specific than just an L-shaped bulge. And in that case, the Supreme Court did indicate that after the search, what was found was an innocent lighter and a penknife was found where the officer purported to be this .25 automatic pistol. And in that case, while I understand that it is not binding on this court, the court indicated that the trial court found that a simple bulge in a man's pocket is so basic when the item is small in size and that there are a whole host of lawful items that could mistakenly be perceived as a weapon of some sort. The bulge was so consistent with innocent activity that the trial court found that the officer who searched the defendant did not have a reasonable
But
articulate.
in this case, it's the shape of the bulge and its position on his body, right?
Yes, and in that case, that was also in the defendant's pockets as well, so I would
No,
say.
But I'm sorry, I thought this was like supposed to be across his middle and tucked into the waistband,
Yes, and Your Honor,
not the pocket.
well, so it was above the belt, but also where the pocket also meets. And so I think from an officer's vantage point, he didn't testify that it was not close to his pocket.
No,
It
no,
was-
my point, I'm sorry. My point is that most innocent items like lighters or coin or whatever else, Tic Tacs are not kept under your T-shirt above your waistline, pointing down into your waistline, under the belt, which is my understanding of how the officer described what he saw.
I
Is that
understand.
correct?
Yes, Your Honor, and I think this court must view it with other innocent things that it could be. We have the fact that there was a belt that could have caused a shape of an L at the top part where there was a belt with a buckle that also is consistent with something that's a hard metal object that could have had the same kind of effect as the top part of an L. Additionally, Your Honor, this court also knows that bulges can be caused from many things, including he is a male with the laws of physics. There's other things that are in the same area.
But the officer doesn't have to be right about it, right? That's not what reasonable suspicion is.
Correct. The officer does not have to be right. However, this court must look at the officer's subjective opinion from an objective standpoint of if there's other innocent possessory things that could be contributed to that in determining reasonable suspicion. And so we would still submit that a bulge in itself is not sufficient. And the other information that this court has that they're relying on for reasonable suspicion does not meet to that standard to justify this.
Well, do you think an L-shaped bulge is different from a bulge?
Your Honor, I do not think that an L-shaped bulge in itself without more is sufficient. I think that it is a factor, and I believe that's a closer call if the court determines that it's an L-shaped bulge and with the officer's training that there's more descriptive information about this. But just merely an L-shaped bulge does not change the fact that the court does need more factors than just simply that.
Now, in your brief, you focus some of your attention on the timing of the seizure. Is that part of what you're arguing now? And do we, if we want to rule in your favor, do we need to find that the trial judge was wrong about when the seizure happened?
Your Honor, this court can find one that the even prior to the officer observing the L-shaped bulge, he was seized. And the moment of seizure occurred well before the officer would have had an opportunity to be able to observe this L-shaped bulge. Specifically, there were several commands that were given by Officer Green. This incident happened within 18 seconds from the time of the first command to the point where Officer Green placed his hands on Mr. Greer. There's also,
Well, so just to walk me through, you say several commands.
yes,
The wording is a little hard to hear on the, at least for me, on the body worn camera footage, but at least some of what was said was in the grammatical form of a question, or seemed to be, was like, would you, or what do you, I couldn't tell. There was like, what are you doing, or would you, which are in the form of a question. Which, what would you say, when you say several commands, can you tell me what utterances you are counting as commands?
yes. The first one where the officer calls out to Mr. Green, he just indicates, sir.
So
That
that's not a command, you don't
We
think?
do not consider that's a command. However, when mixed with the comment that he makes immediately after, 1 second can be construed in different ways. While that may be to the officer in his mind, 1 second, that could also be mixed with sir. 1 second could be construed as a command to stop. Immediately after that, 2 seconds later, Officer Green then continues to say what it seems like is, how are you doing, man? Or how are you doing, man? At this point on the video is when Mr. Greer turns around onto one side and sees that an officer is calling out to him. There are 2 officers following him behind, not just Officer Green, but the other officer that did not testify at the hearing.
And just, do you think the seizure has happened at this point in your narrative, or are you not yet to the point of seizure right then?
Your Honor, I believe that when we are conceding that the seizure 100% happened was when Officer Green, after saying, how are you doing? And Mr. Greer says, all right. After that, Officer Green then continues to go closer to him. He walks at a faster pace while another officer is actually running towards Mr. Green, which is not depicted in Officer Green's video, but you can see it on the other video that's in court. So at this point, Mr. Greer indicates, and it's a little unclear as to what the testimony is in the body worn camera. It is a little blurred, where Mr. Greer then says, I'm good, which is a signal and as tries to continue walking. So saying he does not want to have this
And are you
conversation with.
Could you give me a red flag when you're telling me you think the seizure is, or you think the seizure happens then, or are we not quite there yet?
And then
Not quite there yet? Or
not right there,
Okay.
but right after that, Officer Green that says, he asks another question and says, you have anything on you? Do you mind? Do you have anything? And Mr. Greer stops walking completely. And at this point, he is about to kind of stand right next to Mr. Greer, and we believe that it when the questions continue to start, when Mr. Greer stops right there was when the seizure happened, and it certainly happened when he took the turn to go around to stop Mr. Greer's movement from moving forward. And so
When he
those-
steps in front,
yes,
But you think, and it's a little hard to see everybody's feet from the body worn camera footage to tell exactly when your client stops moving relative to when Officer Green kind of pivots around and steps in front of him. You think that your client's stopping motion occurs before Officer Green has kind of pivoted around in front of your client?
yes. At 17:08:50, Officer Green begins to round Mr. Greer, and Mr. Greer taps his pocket and says, "What? Let me." And it kind of sounds like saying they're talking about seeing something.
Yeah, I hear all that. I just am not entirely clear when the forward motion of your client stops relative to those events, but maybe and if this is mission critical, like exactly when there was submission to an adequate display of authority, assuming that what happened up to that point was, and that stopping amounts to submission, when that happened relative to the officer's perception or claimed and credited perception of an L-shaped bulge, we don't have a finding from the trial court about exactly how those two things temporally relate. Is that true?
Correct. The trial court's finding is that Mr. Greer was seized when the officer laid hands on him.
Right. So if it's critical to the correct resolution of this case, which I know in your argument it would not be, but if it were, to know when was the exact moment of seizure. We have one ruling from the trial court that you're arguing is incorrect, which is it was too late to say the moment of laying on of hands. But if that's wrong, we don't really know what the trial court would say about, okay, if you're told trial court, no, that's too late. We don't know about exactly how far before then we don't have a finding about that because the trial court was obviously using a different legal metric for that. And we don't have a finding about how it relates temporally to when the officer saw, on the trial court's view of crediting the officer's testimony, the L-shaped bulge. That's true? But you think we could, well, I know your broadest argument is none of this matters, even at the moment that the officers laid hands on him, and even crediting the testimony of Officer Green, there was still not reasonable articulable suspicion. But assuming that the court didn't agree with that, then on some scenarios, it seems like it might be necessary to send the matter back to the trial court, depending on what legal conclusions the court reached about some of these issues.
Well, so the point of seizure is depicted on the body worn cameras, and a lot of the audio is also depicted on the body worn camera. So the court made a finding which essentially indicated that he was not seized up until that point. So I think that this court can determine that he was seized prior to that without the trial court's finding on that.
I agree with that. That's a legal question that could, and I think there's enough information that we might be able to answer that from the video itself. I'm just not quite sure we could pinpoint the precise moment of that seizure without assistance from the trial court. And the body worn camera footage obviously doesn't completely answer the question of when if the officer did see an L-shaped bulge, when the officer did. It might give you some information about when it might not be feasible for the officer to have seen it, perhaps. But it certainly doesn't, answer the question completely about when the officer perceived that shape, if the officer did, as the officer testified he did.
So yes, Your Honor, and on the body worn camera, it's obvious that the officer's only opportunity to be able to see a bulge, an L-shaped bulge in the middle of, on top of a belt buckle, would be when he had already seized him and prevented his movement. That would be the only angle that.
When you say, I'm sorry, I don't want to, I'm interrupting you, so. When you say when he had already seized him, you mean again, when he stepped in front of him that he could look at him?
Yes.
Okay.
And
Well, sir,
otherwise.
I thought your argument is the seizure was a little bit before then. The seizure was the stopping of your client before the pivot in front of him.
Yes, and if not, the latest seizure would, if the court did not want to go with that argument, then it certainly was prior to him being able to see the L-shaped bulge. And there's actually no opportunity for him to even see it until he had effectively stopped him. And by using movements to stop his movement,
But isn't that simultaneous,
Right.
basically? So how do we know whether he saw? If the last point you think it could possibly be when he cuts in front of him and faces him, is when the seizure happened, you acknowledge that at that point he could see the bulge that he says he saw.
Potentially, if the court is going to give credit to the testimony of Officer Green over what is observed on the body worn camera, yes, if he was in front and that was his testimony, it could potentially have happened simultaneously, but he would have never had that opportunity without the illegal seizure.
And when you say credit over, you're not arguing that you can tell on the body worn camera footage that there couldn't have been a perceptible bulge, or are you? My takeaway was a little bit different, and you can persuade me that it was wrong for sure, but my takeaway was more, you can't really so much clearly see one. You can't really know for sure what an officer might or might not have been able to see who was there, as opposed to looking through a body worn camera footage. But are you arguing that the body worn camera footage, if we look at it, we'll just say there's obviously no bulge there, and that can't be right? And if the trial court believed it in the face of that, it'd be like, if somebody said there was a flying saucer over the defendant's head, it's like, well, obviously there is, and I can see there wasn't. You're not arguing it's like that, or are you?
No. So while there may be merit that the body worn camera may not show every single thing due to the angle of the body worn camera where the officer is looking and when he's turning, the photos that the officer took after actually have a better angle, a better view, a close up view, and you're still not able to see it. So the court can rely on that objective information. And these are I would argue, is almost like the best situation where the officer was able to have it in good lighting with no movement, with no with nothing in the way and that this is a close-up view. And at no point does the officer say in these photos, when he's describing them, this is not what I saw something more. He actually just confirms, yes, this is where it is. This is right here. And so I would say that the photos are the best evidence in this role of what, in this case, of what the officer saw and says he saw over the body worn camera.
And these are remind me, and these were photos that are taken from the body worn camera, or are these separate photos that are taken? Tell me about the photos.
So the photos, the testimony is that the officer did take photos with an iPhone.
Yeah, okay,
And-
but that at the moment there before, because there's one that actually shows him like removing the gun, but it's, I mean, that looks to me like almost like a reenactment as opposed to the actual moment. What is it supposed to be?
I believe there was also a photo of a still shot of a body worn camera. And so
that one's
there
from the-
was a combination of iPhone photos and still shot of a body worn camera.
Does the record say whether, after your client was down on the ground, did they take the gun out then and then for purposes of these photos, put it back in?
No, Your Honor, the officers handcuffed my client while he was still on the ground. Then they picked him up and then they took the photos and then removed the gun.
So the photos are supposedly show the situation as it was before they touched the gun.
Except for the fact that the shirt was covering the handle of the gun, which is
And-
depicted in the photos.
Right, but I mean, there are some photos where you don't see the actual gun, you just see the T-shirt.
Yes, it's an accurate reflection.
Okay, thank you.
Although, I mean, I take your line of argument that if these photos after the fact with the shirt lifted up don't show a L-shaped bulge, then that could lead you to doubt that the officer had perceived one earlier with the shirt down. So I get that line of thinking, but by the time those photos are taken, and there's been a big struggle, and who knows what's going on with what happens to the gun while everybody's, I mean, it's relatively forceful struggle going on. So it's not as though it's like we know the gun is exactly where it was at the time the officer was viewing it and testifying that he was able to see an L-shaped bulge. Is that true, or you think that's not accurate?
I think that's an accurate statement that the best evidence that this court has to review is just the body worn camera of Mr. Greer walking, which is the best evidence that this court would have. We wouldn't be able to know what it looked like from every angle before the struggle.
Of him walking, because again, you know, if you're walking, actually the shirt, the movement itself might press the shirt against an object so that it might be more visible than when you're standing still, right?
Mr. Greer also had compression pants, compression shorts on. He also had another
But
layer.
those were in essence, I mean, I'm thinking the L-shaped is above the compression shorts, as I understand it, right?
Based on the testimony of officers in this case, that's how it appears to be.
Right. And he's wearing a T-shirt that would have been under the gun and then another one on top.
Yes.
Is that correct? Was there a third garment,
There,
like a white something or other?
yes.
Yeah, okay.
So, Your Honor, I understand that the court is indicating if they were to see the L-shaped bulge, would that be sufficient? And I guess our argument is that there would have been no opportunity prior to him stepping in front. So the L-shaped bulge should not be considered as one of the factors for reasonable suspicion. He was
Because the
affected.
stepping in front was a prerequisite to seeing it, and that itself, almost by definition, means that the seizure preceded the observation.
Correct, that is our position. And so that is not a factor. So the court could only rely on the testimony of blading, high crime, which are all conclusory statements. And those would have been the only two factors left if the court does not consider a bulge.
I mean, but how do we know that it's just, you said, that it's only when the officer is right in front that he can see it, as opposed to when he's, like you said, rounding him and it's a continuous motion.
Well, Your Honor, I would also argue that Mr. Greer was still indicating that he did not want to have contact, and Officer Green was continually pressing and asking questions that would make someone feel that they were not going to be free to leave, especially an African-American male in the District of Columbia that might have had experiences otherwise.
But
And that
you would agree that the earliest moment of seizure is when your client stopped walking? Or would you
Yes,
disagree?
and when
'Cause that would
Officer,
have to be some submission, and that would be your argument, what would be the submission to the display of authority? So
yes,
that's the earliest. The latest in your view is stopping in front, and in between, not 100% precise. Your view is before stepping in front.
yes.
Is that fair?
Yes, as soon as Officer Green started rounding is when we would say was the initial seizure and when Mr. Green felt that he had to stop. And with the continued questioning at the same time regarding if he had anything on him.
And I apologize if I asked this question before and you answered it to the best of your ability, and I didn't fully focus on it, but in your view, do you think you can tell from the body worn camera footage if the moment of seizure were or at least for a minute, for measuring purposes, the earliest moment of seizure is when your client stopped walking. Can you tell, in your view, does the body worn camera footage tell you where exactly Officer Green is relative to your client at the moment your client stops?
Yes,
And where, like, behind, rounding, all the way, where do you?
you are able to see how far of a distance Mr. Greer is from Officer Green on the video, right when he stops. And
Yeah,
right when
I
he-
just found, I mean, I looked at it and I will look at it again with this exact question in mind, but because it didn't really show feet, the movement of feet because of where the body worn camera was oriented. It was a little blurry to me exactly exactly where Officer Green was when your client stopped moving forward. That might be ascertainable, but I was a little unsure about it.
It looks like, I mean, the point is 17:08:50 is what I've pinpointed, and it almost appears of Mr. Greer is saying, possibly let me go, or what do you want? And those are all just obviously, but those are the only words I can make out is what ... let me. That seems like that would be Mr. Greer continuing to try to get away from the officer, not wanting to have contact with him, and Officer Green still continually pursuing him. And then that's when the roundabout turn comes around right after that statement, or almost simultaneously as that statement.
But what I understand is that Judge McLeese is trying to ascertain exactly at what point he stopped, not. I mean, his statements, as you say, suggest that he wanted not to stop. He wanted to continue with his forward motion, but at some point he does stop, and the question is, because that would be the seizure, right?
Yes. You can't see the exact, it's not completely on his feet, so you can't tell, but it's evident from the body worn camera that he feels the need to continue to have interaction and dispel the questions that this officer is asking him, and to continuously defend himself.
I guess one way to think about it kind of inferentially is that he stopped in sufficient time that the officer was able to round him without having him smack into it, right?
Yes,
Right.
I
So
believe
he wasn't moving.
it was a very fast
Yes.
moment. I believe it was 3 seconds at most between the time that he was rounding him to the time that he was in front of him. So this is all extremely fast, which I do think makes it difficult, but that also should go into the factor that all of these questions happened in a moment of 18 seconds. And so these are repeated questions, repeated requests to talk to him. And no reasonable person would feel that they could just go away and go about, because Officer Green was persistent in continuing the questioning. And Your Honor, I think that is my time, unless this court has any other questions.
Thank you. We'll
Thank
give
you.
you some time on rebuttal.
May it please this court, Michael Lee on behalf of the United States. Officer Green had reasonable articulable suspicion to stop Mr. Greer right at the moment where he said to Mr. Greer, "Sir, you have anything in front of you? You have anything on you?" And this is right about the time where Officer Greer begins to round Mr. Greer as counsel was just discussing. And this is evident from the body worn camera, particularly Officer Ishikui's body worn camera, who's the second officer on the scene, as well as Officer Green's testimony during the suppression hearing. So if we look specifically at Officer Ishikui's body worn camera, there's a moment where both officers, Officer Green and Officer Ishikui, are approaching Mr. Greer. They're walking north on Georgia Avenue. Words are said between them. The exact words are, Officer Green first says to Mr. Greer, "Sir," 1 second. There's no response. After that, Officer Green says, "How you doing, man?" Mr. Greer says, "All right." And then Officer Green, he makes some garbled words, which I believe he testifies at the suppression hearing, says something along the lines of, "Would you?" It's not a complete sentence. Mr. Greer says, "What? I'm good." And at that point, Mr. Greer's body is turned to the side, just about as I am now. He's turned to his right. Officer Greer at that point, before he asks any questions about Mr. Greer having anything on him, starts to round Mr. Greer. And Officer Greer's body is turned to his left. At the moment where he passes Mr. Greer, when Officer Green begins to pass Mr. Greer, as you can see on Officer Ishikui's body worn camera, their bodies are parallel to one another. Officer Greer would have a full frontal view of Mr. Green.
So he could have seen it then, maybe, but is there testimony that he did and a finding by the trial court that he saw it then?
There is not specific testimony with regards to the exact moment that Officer Green saw the bulge, but he did testify on direct, cross, and redirect that the bulge was clearly the outline of a firearm. And what you see, taking that testimony also into account of the body worn camera, when Officer Green begins to round Mr. Greer and the two are parallel to one another, his eyes are directly locked on to Mr. Greer's waist area, and he is pointing exactly at Mr. Greer's waist area. So from here, the reasonable inference would be
So,
that
and that might be a good argument to a finder of fact, which we are not. And so if there's no finding on it, I mean, maybe a fact finder would be persuaded by that argument to say, yes, I'm going to find, if it's legally relevant to the resolution of this matter, that I'll find that that was the moment. Despite there being like no direct testimony from the officer kind of just doesn't have a temporal, precise timing of sight from the testimony as I saw it. But are you saying that that's so clear from the video that we should sort of find that as a matter of appellate fact?
yes, Your Honor. Specifically from Officer Ishikui's video.
And, okay, so that's what he sees it.
And it's at that moment that where the pointing is and where Officer Green's eyes are locked towards Mr. Greer's waistband, it's at that exact moment that the first question comes out.
Does he say, is there any testimony in the record that he thinks that Officer Green thinks he saw the gun before this time, or are we all agreed that he first saw it around this time? He thought that he had it because of the blading and what Officer Ishakwa said, but is it clear from his testimony that we are talking about that particular turn and when he was facing him?
Your Honor, I think the records, the transcripts are clear that the gun wouldn't have been seen before
Okay.
that moment. What we do have is Officer Green's testimony that Officer Ishikui signaled him that when Officer Green he noticed Mr. Greer because Officer Ishikui grabbed his waistband and shook it and then pointed towards Mr. Greer. You could actually see in Officer Ishikui's body worn camera footage a hand motion where it appears to be that Officer Ishikui was
You
actually.
can see that, but you also can see how far away Officer Ishikui is from him. So it's, I mean, I am curious whether to what extent that evidence of the other officer, thinking he sees the gun is something we can take into consideration.
I certainly think that it is relevant and important to that Officer Green's perception of what he believed Officer Ishikui was trying to convey to him is important because it puts him on notice. It put Officer Green on notice of where he thought this contraband, presumably a
But
firearm.
isn't it a problem that we can't, we have no way of judging the other officer's, perception, what he saw, the reasonableness of it?
Right.
Because there's just no, he didn't testify, we don't know anything about it.
Officer Ishikori did not testify, but I actually think that his body worn camera footage is telling. What you see in the footage that was record when he first came into contact with Mr. Greer, Officer Ishikori. The Georgia Avenue was cut off. It was a crime scene. You can see that clearly in his body worn camera footage. And this was on the testimony, there was another street that Georgia Avenue kind of beat off with. That was New Hampshire Avenue. You can see that there are two police cruisers that are on that street. Their emergency lights are off. They're blocking off the crime scene. And then there's crime tape all around the perimeter. There were a lot of people out that afternoon, as you can see in the body worn camera footage, but Mr. Greer specifically cut in front of both of the cruisers that were cutting off Georgia Avenue with emergency lights. There's actually an elderly gentleman who was in a wheelchair who didn't do that. He actually went around the front of those police cruisers to cross the street. Mr. Greer, on the other hand, walked through that area, kind of skirting the line of the police tape.
That seems like someone who's not very nervous then about running into police.
It was rather nonchalant, but I think what's important there is that it brought Officer Ishikori's attention to Mr. Greer because he was the only one who walked through there. The officers were not there specifically for Mr. Greer. They were there to investigate the drive-by shooting that had just recently occurred. But at that moment where you have one individual who's essentially skirting through the edge of the crime scene where no one else is doing that, particularly when there are cruisers that are blocking the area, I would say that reasonably drew Officer Ishikori's attention directly to Mr. Greer.
That's a lot of very specific facts you're asking us to glean from a video without any testimony explaining it. And sounds like facts that the judge herself didn't really take into account. She seemed to be trying to stay away from the Officer Ishikori's, his perception of the gun.
Right, there was no specific testimony to that regard though, but I do think that the reasonable inference could be made there.
Can I ask you on an aspect of Judge Beckwith's question that my recollection is vague. I'm going to try to check the transcript in a second here, but my recollection is that when the Officer Green first referred to the signal that he got from Officer Ishakwu, if that's vaguely right, the trial court said there was kind of an objection, and the trial court said something like indicating that it was not even clear the trial court was taking that as kind of substantive proof of a Fourth Amendment violation rather than more in the nature of it explains why things happened the way they did and might be relevant to the point you were making about why Officer Green might well have been focused on the waistband of Mr. Greer in a way that otherwise you'd wonder why he might have been so interested or looking in that way, whereas that puts it in a context. But do you think the trial court admitted the reference to the kind of gestures by Officer Ishakwu and how Officer Green interpreted them as substantive information that tended to itself be a possible factor contributing to reasonable articulable suspicion rather than contextual information that might help the trial court assess the actual factors?
I do agree that the transcript, the court was a little hesitant when it initially received that particular evidence, but I do think that it factored into its calculus, certainly with regards to the way Officer Green perceived the situation. And also on cross-examination, Officer Green did testify with regards to Officer Ishikori's observations that day, specifically with regards to what information was in the Gerstein.
But the judge, I think what happened is the prosecutor, was questioning the officer, I think, and the officer started talking about what the other officer was signaling to him. And I think the judge said, wait, or maybe the defense objected, but the prosecutor said hearsay can come in at a suppression hearing. And I think the judge said, that's not, there's another problem besides it being hearsay. It's not, it's like speculative or something like that. Is that, I got the impression she was like, I'm not considering that. Maybe like Judge McLeese says, I'll consider it as evidence of why Officer Green acted the way he did, but I wouldn't consider it as a factor in support of reasonable suspicion.
I do understand, again, and to answer your Honor's question, that the record, again, I believe the trial court was a little hesitant with regards to its initial receipt of that evidence. Do agree that it went somewhat into its calculus, but I also believe that this court can consider that. This court does not have to rely on the trial court's determinations, but can
What
look
weight,
at the evidence.
what weight do you, assuming we could, which, assuming we could, what weight do you think appropriate would a reasonable judge and therefore a reasonable officer also, I mean, what weight should be given to an indication testimony? I mean, so imagine the trial court had said, yes, I am considering this substantively. Officer Green says, for reasons I can't tell you anything about why Officer Ishaq-Wu did this. I haven't spoken to him. He's not here testifying, and I am not in a position to testify on a hearsay basis about why Officer Ishaq-Wu did this. But Officer Ishaq-Wu did make a gesture to me, obviously referring to Mr. Green, Mr. Greer, indicating that for unknown reasons, Officer Ishaq-Wu apparently had some belief that he wanted to communicate to Officer Green that there was, might be, could be something of interest in the waistband area of Mr. Greer. Like how much weight would that appropriately be given?
Well, it's certainly one of many factors that the court could take into account, but what I do think.
Well, I guess you say it certainly. What is there? Are you aware of legal support for the idea that a statement from Officer A to Officer B that says at the time, but also thereafter, is never shown? There's never any basis shown for it, but it's just a statement. I suspect that a crime is being, I suspect a crime is being committed for unstated reasons.
Well, what I believe is
what makes you think that has a non-zero value on the merits?
what I believe is most important in this situation is more so how Officer Green perceived that information and how it went into his frame of mind when he approached Mr. Greer, excuse me. I think that's where it's more most important in this specific case.
But isn't it also, I would think, the specificity of the gesture by the officer to office that Officer Green perceives? In other words, it's not just, I think this guy might have a gun. It's that he kind of shows, it's the belt, the jiggling, which suggests, I think I've seen something, right?
Yes, Your Honor.
So it isn't totally, I mean, there's a reason, bearing in mind what Judge Beckwith said about the distance, but that there's a reason why Officer Green might have thought, I think my colleague has just seen something. He's telling me where he thinks the gun is. It isn't just, for example, we recently had a case where the MPD gets a tip from Prince George's County Police. We think there's a guy with a gun just crossing to DC. No information about why they think it, where they want, none of that. I mean, here it's a little bit more specific than that in the sense that there seems to be an indication as to where the firearm might be found.
Yes, and I believe Officer Green testified to that. He stated that he took it to Officer Ishaq-Wu's gesture to mean that there was something in that specific area, a firearm.
Right.
Can I ask you just to clarify one thing? Do you agree that there was not reasonable articulable suspicion until Officer Green saw the L-shaped bulge?
I would say that the L-shaped bulge tied everything together. And when he saw the L-shaped bulge, that in itself, it wasn't just an L-shaped bulge. He specifically said he clearly saw the outline of a firearm. That in itself was reasonable suspicion for him to effectuate a stop.
Right, but back to my exact question. Do you agree or disagree that until that moment, there was not reasonable articulable suspicion?
I would say that when the bulge gave with everything else, reasonable suspicion here for the stop.
And it did not exist before then?
Yes, Your Honor.
So, okay, so now we go back to the other question, which is, and relative to when was he seized, was that sighting of the L-shaped bulge?
The exact moment, the government's position is that, as the trial court found that Mr. Greer was seized when the officers grabbed him. And I do think that the actions of that case, were, I mean, when they grabbed him, certainly that was intrusive. But what happened here, the circumstances that led up to it, even with Officer Green's questionings, the circumstances that led up to the questioning after the first, do you have anything in front of you? Do you have anything on you? Were not significantly intrusive. It was daylight out. There was multiple people on the street.
Can I pull two things apart? So there's a question of whether there was an adequate display of authority. And there's a question of whether and if so, when there was submission. And so on the submission piece of it, your comments right now are going more to the question of whether there was when there became, your view is there apparently was not an adequate display of authority that could amount to a seizure. So that if there's a seizure here, it's only by the grabbing a hold, if I understand your position. But just on the question of submission, assume for a moment that there was an adequate display of authority by the time Mr. Greer, I keep wanting to be Greer and Green. I have a hard time keeping oriented on this, but by the time Mr. Greer stopped, would you agree that if what happened up to them was an adequate display of authority, the stop would be submission? Or do you think that more would have had to have been done to be submission?
Yes, Your Honor, I'm sorry, I don't want to confuse myself. If you can repeat the last question.
Right. So my question is, assume that right at the second before Mr. Greer stopped walking, there had been an adequate display of authority. Would you agree that the stopping would itself be submission to that display of authority?
I would say that there would be a submission, yes.
So the issue for you is, I was trying to figure out whether there are two things at issue or only one, and it sounds like your issue is you think there was submission. If there had been a display of authority, the stop would be submission. So the question is only, was there an adequate display of authority to make it a seizure if there was submission, which you're conceding there was? Yeah, so it's only one issue, not two, is what I'm gathering from what you're saying.
Yes, Your Honor.
Okay. And so I mean, I know you said the Kelly case, which is kind of old interdiction kind of scenario, but our more recent cases seem to make it a little difficult to argue there was no sufficient display of authority from the combination of, so we know, I mean, it looks as though there would be two officers visible to Mr. Greer as he's turning around, pretty close together, coming towards him. And then you have the sequence of events and the repeated questions and like what seems like not satisfaction with denials of problems or refusals or unwillingness to consent to searches and the like. And then if we take for as the hardest piece of it for you, and then stepping in front of someone who was walking and seemed to be wanting to continue to walk, why would that not be under our case law, or, you know, in particular our more recent cases and the analysis in them? Why would that not be a sufficient display of authority?
Yes, Your Honor. With regards to recent case law, I do think that factually this case, the incident cases can be differentiated. This incident happened during the daytime. It happened on a pretty busy street. There were officers out on the street, but they were there focused specifically on the drive-by shooting. The officers that were focused on Mr. Greer were particularly Officer Green and Officer Ishikue. When officers were approaching Mr. Greer, they passed, at least from my count, I believe Officer Green testified at the suppression hearing that there was 10 to 15 civilians out on the street at the time. He was very accurate. The body worn camera, from my view, shows there is at least 15 adult civilians that they passed. And at the moment where Mr. Greer stopped and he was actually grabbed by officers, there were 6 adult civilians out on the street. 2 of those individuals had baby strollers with them. One had a baby, an infant in the stroller. Another, who was a female, was walking with her toddler.
I understand that, but you say at the moment that he was tackled.
Yes,
Okay, but that, there's no question that that's a seizure.
yes,
No matter how many civilians and babies are around, that's a seizure.
but my point, Your Honor, would be that those individuals, the civilians who were out on the street, they didn't seem to be alarmed when this happened. So if we're contrasting the scenario, for example, with what happened in Golden, where there are civilians out in a parking lot, when the interaction began with the police officers, those individuals scattered.
Why?
But the difference to me, I'm
No,
sorry,
this
is
is
that when Officer Green was testifying at the motion to suppress, he was asked whether, when he said whether he had blocked Mr. Greer. And Officer Green said, yes, basically that he blocked him. So in many of the other cases, we're looking at the whole circumstances around it to see, in other words, was a person effectively blocked? Would it have been reasonable for a person under those circumstances to feel that he couldn't continue? Here we have the officer basically saying he was blocked. I was blocking him. So why isn't that that's the seizure right there?
Well, I would go back and look at the transcript. I do understand, and it's very clear, and of course, Officer Green testified that he walked
No,
in front of.
blocked. He uses the word, I mean, he's asked whether he blocked him and he says yes.
But if we look at the body worn camera footage at the intersection where the blocking happened. There's a Dunkin' Donuts to the left, and Mr. Greer's egress was not blocked towards that area. He could have taken a left on the street.
But wasn't the testimony and that as soon, or from Officer Green, that as soon as he did apparently lean to the left, although I can't see that in the video, he was tackled. So is he really free to go one way or the other?
But I would say that from an objective point of view, a reasonable person, Mr. Greer didn't know that he was going to be tackled at that exact moment.
Fair enough, but it seems to me you might be kind of failing to appreciate a possible distinction between being surrounded and being blocked. So Mr. Greer was walking in a direction. It seemed like what he wanted to do if the police hadn't been interacting with him. And an officer came around and literally stood in front of that direction. Now, it's true he wasn't surrounded, so he could have gone to the left, he could have gone to the right. I don't know if he could have gone back. There's also Officer Shockwave who'd be part of an obstacle, I guess, but he's certainly not surrounded, fair enough. But his motion, his direction of motion was prior intended motion was blocked. It seems like it'd be fair to say. Just speaking practically, if you're saying that a reasonable person walking down the street, an officer comes from behind, and it's the exact encounter here. So the officer obviously wants to talk to you. The person is communicating, don't want to talk to you. I'm on the phone. I'm fine. I'm not going to lift up my shirt. I want to keep walking. I have no interest in interacting with you. The officer instead keeps asking these questions, not satisfied, steps in front of the person who obviously wants to walk away. You're saying you think a reasonable person should think, if I want to turn left, fine. This is not a display of authority. This is an officer who apparently is really eager to chat with me on a voluntary basis. That seems like a tough argument, I guess. And do you have a case that is like it in the sense of someone who, the combination, I get daylight, there's some circumstances that are favorable to your argument for sure. But if you take the ones that are unfavorable, it is, someone who is walking, who's repeatedly indicated a lack of interest in further interaction, an officer who makes nevertheless repeated requests, all of which are denied. And then the officer literally steps in front of the path of movement of the person. That's not a seizure. That's not a display of authority. Submission is a separate topic, but that's not a display of authority. Can you point us to a case that looks like that? I mean, Kelly's not that. The interdiction case, which is one of the cases you relied upon.
Other than Kelly, Your Honor, I don't have a specific case to cite to, but Mr. Greer never told officers that to leave him alone or that he didn't want to speak with them. Those words never came out of his mouth. That wasn't testified to, it wasn't on the record, and it wasn't in the body worn camera footage.
Well, it's pretty obvious actually in the body worn camera, don't you think? I mean, he's giving short answers and continues to walk. I'm good sort of means,
Leave me alone.
yeah, leave me alone.
I mean, look, if what you're saying, the hypothetical you're positing is that if Mr. Greer, once Officer Green steps in front of him, according to Officer Green blocking him, he could have said, come on, man, I'm gonna go over to Dunkin' Donuts now. He could have just, he should have felt he could have just done that. without any physical repercussions under the circumstances?
Well, I think everything leading up to that point, prior to Officer Green asking Mr. Greer questions with regards to if he has anything on him, that was just a consensual encounter between the two. I don't think that there is anything aggressive on Officer Green or Officer Ishikoi's behalf leading up to that point at all.
And Mr. Greer is consensually saying, I don't want to talk to you, basically, right? Leave me alone. I'm good.
He did say I'm good. He did not say I'm good, but I do also believe officers have a right to speak with people on the street when they're investigating. And that's the right that Officer Green was using when he approached Mr. Greer originally.
Why, by the way, isn't this what eventually happened, a full-fledged arrest? Like, I can see maybe a Terry stop will remain a frisk for purposes of Terry if they're trying to, a person will not be handcuffed or will not be, will not calm down. I can see that leading to what happened here, but here it is so fast. It goes from a conversation to tackled. I guess that it's not been argued, or it's been only partially argued, but isn't this an arrest?
Well, as Officer Green testified to at the suppression hearing, and the court did credit his testimony, he stated that he saw Mr. Greer take a short step to his left, and it was his belief at that moment that he was going to try to escape.
Do you see that in the video? Because to me, it looks like any movement only comes after he's being grabbed, sort of reflexively.
Admittedly, the body work came from what I saw. It's body work. It doesn't capture everything, certainly, that an officer saw, but I do believe the court made that determination.
Based on the officers, again, was it based on crediting what the officer said or based on what the trial judge saw?
I don't think it's clear from the record of how that determination specifically was made, but the court did, I mean, not with regard to the body worn camera, but the court did make a comment or did comment about pictures, saying that her determination had to do with more so not just what the pictures did or did not show, but her belief, her crediting of Officer Green's testimony. But I don't believe, as Your Honor just asked, that the court specifically made a finding that would answer your question. And if there are no other questions, the government would submit that the trial court's judgment should be affirmed, ruling should be affirmed, excuse me.
Thank you very much. Ms. Patel, we'll give you 3 minutes.
Keep it brief. Your Honor, previously when I spoke, the court had asked us if there was an exact moment or testimony in the transcript on when exactly Officer Greer was able to see the L-shaped bulge. And looking back on the testimony on page 75 of the transcript, starting with question 1, the question is asked, what drew your attention to him when you spoke to him at the end of the block? The answer, starting on line 3 through 5. When I first walked up and I tried to get Mr. Greer's attention, he bladed his body, and that's why I walked to the front. And then I observed the outline. So we would submit that the testimony only supports the position that Mr. Greer would only be able to, the Officer Green would only be able to see Mr. Greer's L-shaped bulge based on his testimony when he walked in front of him, and that's when he was able to see it. So the record is clear on that. The court did not seem to make that finding in its factual finding specifically, but that the testimony is there to support that finding. Second, perception. I know that the court went into the perception. We believe that very little weight, if not zero weight, should be given to any perception of what this officer that did not testify indicated. I mean, the only testimony that the court has is that he made some kind of signal, and that signal was based on we do not know what. Even if the court was to give credit to what why the officer did what he did next, which is follow Mr. Greer, that does not go towards reasonable suspicion. That just goes towards why the officer did what he did, which is follow Mr. Greer. We would argue that that's not a factor. The The blading, once again, it's a perception of the officer. And when you look at the body worn camera, all you see is an individual that's walking on the phone with one hand in his phone and turning back because someone called out to him and said, "Sir, one sec." And
But
so
we're perceiving that as non-police officers. Maybe if we were police officers, we'd see it as blading.
But that still, and when the officer was questioned, what is blading? He said when he turned his body to turning his body at an angle. That does not correlate to what he is trying to hide. If anything, that's actually more consistent with someone turning around when someone is called upon. Further, there's other testimony that the court relied on of his hand movements that's observed on the body worn camera, indicating some kind of furtive movements or perhaps him trying to conceal something right prior to the one step that the government is saying that Mr. Greer took. When you look at the body worn camera, it actually just shows a movement of a hand and then actually shows him opening up his hand almost to disprove that he doesn't have anything on him.
It also seemed like at some point he was patting his leg or something like that. Is that something you saw also, or?
Yes, and that is more consistent with someone trying to disprove, say, "I do not have anything on me, leave me alone."
Yeah, I guess I have I have a question about the form of reasoning you're using now, which is to take, like, let's say blading or turning to talk to somebody behind you, and it absolutely could be either. I mean, I could take your point that that's something that someone who's called from behind and talking on the phone could have moved his or her body in exactly the way that's seen here. So for sure, it's not, it is entirely consistent with innocent conduct, for sure. But to say the mode of reasoning seems to be in the nature of, well, since it's more likely innocent, it's not appropriately considered as one of the factors that contributes at all. And I'm not quite sure that's the mode of analysis. Similar question, I guess, about Officer Ishaku's testimony, which the trial court didn't rely on, and I'm not sure the trial court even admitted as kind of a substantive proof of a factor. But if the issue were really at the moment the officer sees the L-shaped bulge, assuming the officer did, the officer had reasonable articulable suspicion. If to say, okay, here's some other things that are on my mind as an officer and as a judge determining whether that's reasonable. I don't know why, but one of my colleagues warned me that there might be a weapon in this person's waistband. I would think a reasonable person would have that in mind and think like, I don't know the basis for it, so I'm not going to give it a ton, but it's not like it's zero. It'd be something that, you would think, well, I should factor that in as making what was done reasonable. And if, the person, when I tried to engage him from behind, he turned, now it might have been innocent, but on the other hand, it's entirely consistent with how you would, twist your body if you were trying to hide a gun. So that also is, contributing to the whole picture in my mind. I'm not sure that any given one of them is more likely than not innocent means it is of zero value. I agree, it affects the weight of the value, but do you think that if, like blading, you think that assuming it's true, it's equally consistent with innocence as with hiding a weapon that might be there if one is? Do you think that means has zero value, or are you just saying something about the weight of it as a value?
Well, I think that we still have to look, the court still has to look at, just because an officer says something relates to reasonable suspicion does not make it so. For instance, just because an officer said standing at an angle is consistent with someone hiding a gun, the court still has to look at objectively what the officer is seeing and see if that is actually an individual trying to conceal something. In this situation, what the officer purports to be blading is simply a man turning around and then turning back around to walk its way. TW in the United States kind of goes into this where there's a different analysis of raising your hands, where one person may say that's a consciousness of guilt, but the courts disagreed and said raising one's hand is eminently sensible thing for anybody to do when sworn by police officers in this manner, particularly a young Black man in a heavily patrolled area. So that's just one scenario where one movement can be interpreted in two different ways. And in that case, in TW, the court did not give the same weight that the trial court gave to raising your hands as a sign of guilt. And I think that is my time unless the court has any more questions. Thank you.
Thank you very much. Thank you both for your briefs and your arguments today. The case will be submitted.
All rise. This honorable court is now adjourned.